Good day to all of the law students across the Philippines. This is Hannah from PUP College of Law, your host for today. I would like to welcome everybody to Central Book's Best Pre-Week Ever Bar Lecture Series 2025. For today's lecture, we will have a review for the subject Criminal Law. If you would like to see our other lectures with Central Books, please visit our official Facebook page at Central Books. We would also like to recognize our main sponsors for this initiative, Central Books and Rex Bookstore. On behalf of the Philippine Association of Law Schools, I would like to extend our heartfelt thanks for your generous sponsorship. With that, it is my honor to introduce our esteemed lecturer for today for Criminal Law. Babasahin ko na. Prosecutor Nojara is presently the Deputy City Prosecutor of the Office of the City Prosecutor in Antipolo City. At the same time, he is a part-time law professor teaching criminal law subject at various colleges of law in Metro Manila and nearby provinces. He is also a pre-bar reviewer in criminal law at Recoletos Law Center, Villasis Law Center, University of the Philippines Bar Review Institute, Powerhouse Law Review Center, and Lex Scholarium Bar Review. In addition, he is well-renowned lecturer of mandatory continuing legal education, or MCLE, of various MCLE providers such as Access, UP Institute for Administration of Justice, New Era University College of Law, IBP Rizal, IBP Cavite, IBP Albay, IBP Nueva Ecija, IBP Tarlac, and IBP Quezon. Prior to his appointment as prosecutor, he was an active law practitioner. He served as associates of various law offices in Makati City and Pasig City. He also had a stint at the Manila Electric Company, or Meralco, where he served at its legal services until his retirement with the rank of senior manager. Prosecutor Nojara obtained his degree of Bachelor of Arts, major in Political Science, from the University of Nueva Cáceres, Naga City. He finished both his Juris Doctor and Master of Laws at San Sebastian College, Recoletos in Manila. He has authored his books entitled Special Penal Laws, Concepts and Jurisprudence, and Concepts and Jurisprudence of the Comprehensive Dangerous Drugs Act of 2002. Let us all welcome Prosecutor Freddie M. Nojara.
Good day to all. Welcome to the best pre-week ever lecture in criminal law. I am Prosecutor Freddie Nojara, your lecturer in this pre-bar lecture series. We'll be discussing criminal law, which is consists of three parts. Number one is the book one of the revised penal code, and number two, book two of the revised penal code, and number three will be special penal laws. So since this is just a special lecture, we will not be discussing the basic concepts of criminal law, but instead we are after the recent jurisprudence of the Supreme Court, which are possible sources of bar examination questions in criminal law this year's bar examination. So I will start my lecture by sharing this simple PowerPoint presentation. Okay, now the number one concept is generality. So if we speak of generality, we are talking about the basic characteristic of criminal law in the Philippines. So generality means that penal laws are binding upon all persons who are living or sojourning in the Philippines. So based on the previous bar questions, bar examinations, there are numerous bar questions taken from this concept. So generality, whether or not our laws or penal laws can be applied to persons living or sojourning in the Philippines. But we are after the exceptions. And one of the exceptions to generality rule is treaty stipulations. So meaning to say, if there is a treaty in which the Philippines has entered into with another country or another state, we are bound to respect that, because there is a concept in international law, the doctrine of pacta sunt servanda, that our treaties and treaty stipulations should be performed in good faith. So if our country decides to enter into treaty with another country, we should respect that. And if there are treaty stipulations, we are bound by that agreement. Okay? So there is one case that I want to share with you under this concept. I'm referring to the case of Westfall case that was decided in 2024. So an international organization, just like the Asian Development Bank, also enjoys immunity under international law, because international organizations are endowed with some degree of international legal personality, okay, so that they can effectively discharge their functions. Just like, for example, the case of Asian Development Bank in the Philippines, or Asian Development Bank, ADB, I'm sorry. This is based in Ortigas, in Pasig. So the personnel of ADB are immune from certain criminal prosecution. In the case of Liang, that was an old case, the Supreme Court made it clear that the immunity does not apply if the act involved is not related to his function. So, for example, in the case of Liang who was a Malaysian, he was charged with the crime of defamation. So, he was an economist working with the ADV. So, Supreme Court said that since defamation or slandering is not connected with his function as an economist of ADB, he is not immune from criminal prosecution. So, for the immunity to apply, the act involved must be related or in connection with his function as a personnel of Asian Development Bank. Now, in Westfall, the Supreme Court, acting in NBank, clarified that before the immunity can be invoked, the court should try its effort to ascertain whether that particular act complained of is necessarily connected with his being an employee or a personnel of ADB. So this, in Westfall versus Locsin, decided by the Supreme Court on April 16, 2024, the Supreme Court said that the court should try to ascertain first whether the act involved is connected with his function. So before you can apply Liang, the Liang doctrine, Westfall doctrine says that there must be some act to be conducted by the court before one can invoke the immunity. Okay? So that's number one. Now, another characteristic of criminal law is prospectivity. The law simply tells us that penal laws shall have prospective application. Meaning, you cannot retroactively apply the law because it will be considered as ex post facto law, which is prohibited under the Constitution. So, you apply the law, the penal law, prospectively. Of course, there are exceptions, and one exception is found in Article 22 of the Revised Penal Code. What does Article 22 say? Article 22 says that law can be retroactively applied if it is favorable to the accused. Yan. So if it is favorable to the accused, you can apply the law retroactively, provided that the accused is not a habitual offender. So exception to the exception, meaning the law cannot be applied retroactively if the accused is a habitual offender. Now, in Peña versus People, this was written. The ponensya of this case is no other than the 2025 chairperson of the bar examination, Justice Amy Javier, that community service law under Republic Act 11362 can be applied retroactively. Why? Because community service is a law that is favorable to the accused. So even if the accused has been convicted and his conviction is affirmed by the Supreme Court later and his judgment becomes final, the offender can still apply for community service even if the act that was committed by him it was committed before the effectivity of Republic Act 11362. So Republic Act 11362 or the community service law is favorable to the accused. So it can be applied retroactively. Now another law or another case which is a possible source of bar exam question, criminal is the case of Bargado. This was decided by the Supreme Court, or the decision was promulgated last July 29, 2024. I've been emphasizing that this is a very good jurisprudence. In Bargado, the accused was charged with violation of gun ban under the Omnibus Election Code because he was caught in possession of a firearm outside his residence. Now, he moved to quash the information, citing that under Republic Act 10952, the barangay elections were postponed. So, in 2017, October, the barangay elections were supposed to be conducted. But the Congress passed this law on October 2, 2027, which postponed the barangay elections. So, Bargado was caught in possession of firearm October 1, 2017. I'm sorry, that's a typo error, 2017. A day before the passage of this law. So, on October 1, 2017, Bargado was caught in possession of firearm. A day after, the Congress passed a law, Republic Act 10952. Now, the question is, can Bargado move to quash the information, citing that since the barangay elections were postponed, he did not violate the gun ban under the Omnibus Election Code because, the gun ban violation is only possible if there is an election or if the act is committed during the election period. Since the barangay elections were postponed, there is no election period to speak of. Now, the Supreme Court said, yes, Bargado's contention is correct. The law, Republic Act 10952, partakes the nature of a penal law. While Republic Act 10952 neither defines nor prescribes a penalty, it inextricably relates to the election period for the original scheduled October 2017 election. So meaning, even if this is not a penal law, but it is related to the election period prescribed by the Omnibus Election Code. Therefore, this can be applied retroactively. So Article 22 applies to this case because this law declaring a new election date is inextricably, that's the word, inextricably linked to the determination of violations under the Omnibus election code. So watch out for this question based on this Bargado versus People. Now, another interesting case in the matter of prospectivity is the case of People versus Triple Y. This is an en banc decision of the Supreme Court rendered February 20, 2024. Now, I am expecting a question from this, People versus Triple Y. Originally, it was entitled People versus Pineda. Pineda, a resident of Pampanga, was charged with violation of Republic Act 9775, otherwise known as the Anti-Child Pornography Act, because she was utilizing her own niece, 6-year-old niece, in committing the crime of child pornography. So, the 6-year-old niece was being shown on the internet doing what they call this pornographic acts. Now, the PNP, the Philippine National Police, armed with a search warrant, searched the house of Pineda in Pampanga. The PNP police applied for a search warrant based on the tip made by the Federal Bureau of Investigation that Pineda was engaged in online child pornography. During the search, the PNP operatives confiscated some pornographic materials from Pineda's laptop or computer. So the computer contained photographs of the child, nude photographs, and those photographs are shown online. Now, Pineda was charged with violation of Republic Act 9775. And he was convicted by the trial court and affirmed by the Court of Appeals. While the case of Pineda was pending appeal before the Supreme Court, the Congress passed Republic Act 11930. Ano ba itong 11930? This is the OSAIC law, or the OSAIC law, Online Sexual Abuse and Exploitation of Children. This law expressly repealed Republic Act 9775. Now, the question here is, since the Republic Act 9775 was repealed, did the repealing law decriminalize child pornography? That's the bone of contention of Pineda. That Pineda was arguing that since the law under which she was charged, it was repealed by Republic Act 11930, there is no more crime committed by her. That's the contention of Pineda. Now, the effect of absolute repeal, it decriminalizes the act. It decriminalizes the crime. So if the crime is decriminalized, there is no crime to speak of. So what is the effect of the repeal? So even if the case is still pending trial or pending appeal before the courts, then it will also be dismissed because the act is decriminalized. Meaning, the law has retroactive application. So if the law is passed today, then all cases, pending cases, even if those cases were committed before the passage of the repealing law, then it will have retroactive application. So that's the contention of Pineda. But the Supreme Court said, Pineda is still liable under the law. Why? Even if the law under which she was charged and convicted was already repealed by a new law. So Supreme Court said, if the subsequent law, in this case, Republic Act 11930, reenacted the same act punishable under the repealed law, which is Republic Act 9775, Pineda is still liable. So even if there is an express repeal of the old law, the new law, if the new law reenacts the same crime, then it continues to be as such. It continues to be a crime under the new law. Parang walang effect yan with respect to Pineda. In the case of Pineda, the crime charge was committed in August 2016 when the prevailing law was Republic Act 9775. The subsequent law, Republic Act 11930, enacted in June 2022, expressly repealed the old law, but at the same time reenacted the unlawful acts defined as child pornography. So, baka may bar question dyan. Now, in mala prohibita, so this is also a good source of, or a rich source of bar examination question. The usual question is what's the distinction between mala inse and mala prohibita, but since the trend of the bar exams now there's no objective question, but essay or problem solving. So maybe the case of Balinsona will be asked in the bar exam. What is this case of Balinsona versus People, decided August 30, 2023? The accused, Balinsona, was the president of a real estate corporation. He was charged with violation of the Subdivision and Condominium Buyers Protective Decree under PD 957. This is a special penal law, or this is a mala prohibita, because allegedly the company failed to register the sale of a condominium with the register of deeds. Under this law, the real estate company should register the sale. Since it failed to register, the private complainant charged Balinsona, the president of the real estate company. He was convicted, but the Supreme Court acquitted him. Why? Even if PD 957 is a malum prohibitum, it is still required that the accused must be proven to have that volition or intent to commit the prohibited act. Ang ibig sabihin dito, what is required in mala prohibita is not the intent to commit the crime, because in mala prohibita, intent is not required, unlike mala inse. But even if intent is not required in mala prohibita, the law requires intent to perpetrate the act. Meaning, you have that volition or the consciousness to commit a certain particular act. But in this case, Balinsona did not have that intent to perpetrate the act. Why? Because he was not involved in the alleged violation, which is non-registration of the subject contracts. It was not the duty or obligation of Balinsona, being the president of the corporation, to commit to register the contract of sale. It was not his duty, since he is the president. It is the duty of other personnel of the company to have the sale registered with the register of deeds. Since it was not his duty, Balinsona did not have the intent to perpetrate the act. Okay. So, that's mala prohibita. Now, we go to conspiracy. So, sasabihin ko na nga, in every bar examinations, questions on conspiracy, palaging mayroon. So, do not forget. You focus, you emphasize your study on conspiracy. Now, what is the latest? Ano bang mga latest on conspiracy? No? One of the cases decided by the Supreme Court in 2022 is the case of People versus Cordial. Cordial was charged with robbery with rape. Now, one of the co-conspirators died, di ba? He died, or assuming he died or he was acquitted. What is the effect of the death or acquittal to the other co-conspirators? So I think the last question was last year. The effect of death or acquittal on co-conspirator. While the accused, who actually committed the sexual assault, died during the trial, the death of that accused does not affect the liability of his co-conspirators for the crime they committed. So this is clear in People versus Cordial that even if one of the co-conspirators passed away, the basis for the conspiracy has not changed since the co-accused still failed to prevent the commission of the sexual assault, even actively participated in consummating the said crime. So since there is conspiracy, the act of one co-conspirator is also the act of the other conspirator. So the legal contemplation that the act of one is the act of all is the basis of the collective liability for all the conspirators. So even if one, assuming there are 3 conspirators, one of them died during the trial of the case, during the pendency of the case, it will not affect the liability of other 2 accused with respect to the crime charge. Now, in People versus Cerezo, this was decided March 15, 2022, that conspiracy of silence or inaction. So, what if one of the co-conspirators did not make any action? He did not lift any finger, so to speak, to prevent the commission of the crime. So, we call him a passive conspirator. In the case of Cerezo et al., a municipal mayor and a contractor were charged for violation of the Anti-Graft and Corrupt Practices Act under Republic Act 1319. The contractor was a supplier of heavy equipment for hauling of garbage. Is the supplier also guilty of anti-graft as co-conspirator? So the Supreme Court said in Cerezo et al. Said that there must be a conscious criminal design evinced by circumstances where the silence of the accused is tantamount to tacit approval of the same. His mere consent to the lease contracts does not ipso facto show that he intentionally participated in the transaction with a view of to the furtherance of the common criminal design and purpose, that is the commission of the crime. There must be a collaboration. The collaboration necessary for the execution of lease contracts does not rise to the level of criminal collaboration. So meaning, the contractor who entered into contract with the mayor is not to be considered as co-conspirators because mere act of entering into contract does not establish conspiracy. There must be an overt act in furtherance of conspiracy. The law requires such overt act to be executed. Mere silence or inaction is not conspiracy. So, where there is absence of any allegations that the contractor entered into contract with knowledge that the same was defective or should have known that the same is defective for failure of the municipality of Benmali, Pangasinan to conduct public bidding with respect to the same is not enough to establish conspiracy. In another case, People versus Arnado, March 21, 2022, the Supreme Court reiterated this settled rule that conspiracy cannot be presumed. That cannot be presumed. There must be evidence to prove conspiracy. That evidence either can be inferred or deduced from the acts of the conspirators. Because in conspiracy, it is required that there must be overt act. Overt act consists of direct participation, moral influence, or moral ascendancy. That must be the overt act required under the existing jurisprudence. In the case of Arnado, a mayor cannot be charged with grave coercions based on the statement of a witness who said that they dismantled the house of the victim upon order of the said mayor. I think this is a complaint for violation of Republic Act 1319, again, the anti-graft. The mayor allegedly ordered the demolition of several houses. So that is a violation of Section 3E of Republic Act 1319. The only basis in implicating the mayor is that there was, and I quote, utos sa taas. So the only basis in implicating the mayor is that he allegedly ordered the demolition of the said houses. Supreme Court said that his participation in the alleged acts of coercion is merely presumed from the statement of the witness who said that there was an utos sa taas, meaning it was the mayor who ordered the demolition. That is not enough to establish conspiracy. So if this will be asked in the bar exam this year, cite People versus Arnado that the conspiracy cannot be presumed. There must be an overt act. And that utos sa taas is not an overt act enough to establish conspiracy. Oh, marami kayong natutunan dito. Puro to bago. Next is Palawag versus People. Now, this was decided July 10, 2023 by the Supreme Court. Now, Palawag introduced to the victim a woman, and that woman wanted to borrow money or to contract a loan or from a certain person. The woman mortgaged her car to the victim. The woman failed to pay the loan. Now, since it was Palawag who introduced the woman to the victim, to the private complainant, the private complainant was charging Palawag as co-conspirator in the crime of estafa. So Palawag and the woman and two others were sued for estafa. So the question, the issue here is whether Palawag can be considered as a co-conspirator when he introduced the woman to the complainant. Now, the Supreme Court said that the overt act of introducing one of the accused to the victim or private complainant is not an overt act in furtherance of conspiracy. The law requires that any overt act performed by the accused must be in furtherance of conspiracy. The act of Palawag in introducing his co-accused to the victim is not overt act required in conspiracy. That act does not show that the accused acted in concert pursuant to his co-accused's objective to defraud the victim. Even if Palawag was present when the transaction between the co-accused and the victim transpired, his presence alone does not make him outright a party to the fraud committed. For him to be held liable as conspirator, it should be shown that he performed an act in furtherance of the fraud's design. Now, marami tayo sa conspiracy, the case of People versus Nicholas et al., January 11, 2023. This is a direct bribery case. Now, in People versus Nicholas, one of the co-accused endorsed the private complainant to Nicholas. Nicholas was I think he was an ombudsman investigator in Pangasinan. Now, one of the accused there was being charged as a co-conspirator in the direct bribery because he was the one who referred the case to Nicholas. Di ba? So parang ganun. So, the Supreme Court, one of the issues raised before the Supreme Court in People versus Nicholas et al., whether the act of introducing or endorsing the case to the co-accused is enough to constitute conspiracy. Now, in this case, the court held that the presence of the co-accused in a meeting for the purpose of, cooking up a scheme to extort money from the victim or for the purpose of getting money from him in return for a favor assistance of facilitating the dismissal of the case filed with the ombudsman is not enough to establish conspiracy. Based on the evidence, it appeared that the accused did not personally and actively seek his presence in said meeting, but was requested only by the victim for the purpose of introducing him to the principal accused who was handling the criminal case. It's a statement that kayo na ang bahala dyan. Just like in the other case, in the case of Palawag, that is not enough to constitute conspiracy. Doon sa Palawag, ang sinabi, utos sa taas. Dito, o bahala na kayo dyan, basta ako dito lang, ikaw na ang bahala magpaliwanag kung ano yan. That is not enough to constitute an overt act in furtherance of conspiracy. Now, next is Hirunda versus People, August 7, 2023. Now, this is a very good law, very good decision since like in the case of Palawag and the case of Nicolas, ganun din ang ginawa ni Hironda. Okay? Now, Hironda introduced Attorney Cabilaw of Toyota. O manager ata siya ng Toyota. Attorney Cabilaw had a transaction with Attorney Diamante who is the Register of Deeds in a certain city or province. Attorney Cabilaw wanted to transfer the name of his title, wanted to transfer the title under his name. Okay? Now, when he was approached by Hironda, who was a personnel of the Register of Deeds. Kumbaga, siya yung runner, errand boy ni Attorney Diamante. Di ba? Siya yung tagalakad. Now, Hironda said, pwede namin ayusin yung problema mo dito because si Attorney Diamante kasi wanted to buy Toyota Vios. Di ba? So, since you are the manager of a certain Toyota car dealer, pwede bang matulungan natin si Attorney Diamante? So, that was the transaction between Hironda and Attorney Cabilaw. So, Attorney Diamante was supposed to make a down payment in the amount of 150,000 for the purchase of Toyota Vios. But Attorney Diamante had not enough money to make the enough money for the down payment. That was the problem of Attorney Diamante. So, ang sabi ni Attorney Cabilaw, sige, yung 50,000 nakakulangan ni Attorney Diamante, ako muna ang magbibigay. Ako muna bahala. So, Attorney Cabilaw gave the 50,000 pesos to Hironda with the instruction that wag mo muna ibibigay yung Attorney Diamante hanggang hindi matatapos yung aming transaction. So, that was the agreement. So, but Attorney Hironda, Mr. Hironda, gave the money to Attorney Diamante even if the transaction was not yet terminated or it was not yet finished. So, the money was given by Attorney Cabilaw to Attorney Diamante through Hironda without the transaction having materialized. So, parang naisahan si Attorney Cabilaw. So, he demanded, where is my title now? So, parang dinideny na ngayon ni Attorney Diamante na there was an agreement to that effect. So, Attorney Cabilaw filed a case for direct bribery under Article 210 of the Revised Penal Code against Attorney Diamante and Hironda. Yan. So, the question here is whether or not Hironda is a co-conspirator. The act of parang siyang naging middleman, the one who received the money on behalf of Attorney Diamante and giving the same to Attorney Diamante. Parang siya yung naging, kumbaga, naging link ng dalawa, ni Attorney Cabilaw and Attorney Diamante. Okay? The Supreme Court said that the liability of Hironda is a mere accomplice. Okay? So he is not a co-conspirator. So, okay? So he is not a co-conspirator. So, can Hironda be convicted of direct bribery even if the information alleged that he was a co-conspirator or a principal in the crime of direct bribery. So the Supreme Court said, since the liability of Heronda is that of an accomplice, even if the information did not state that he was an accomplice, but it will not affect his criminal liability. By knowingly cooperating by previous or simultaneous act, when he received and subsequently delivered the sum of money to Attorney Diamante, that act is not, that will not expose him to the liability of a principal. Ang liability ni Heronda is a mere accomplice. So he is not a co-conspirator. But the problem, or the information did not state that he was a mere accomplice. Is that a fatal defect? Supreme Court said no. Even if the information did not state that he was a co-conspirator, it will not affect his criminal liability even if he was a mere accomplice. Now we go to another topic, persons criminally liable under Article 16 of the Revised Penal Code. Now in People versus Carreño, April 26, 2023, Carreño et al., they were the directors and corporate officers of the corporation, yung Kaliraya Corporation. They were charged with violation of the Securities Regulation Code for making an untruthful statement in the registration statement. The trial court dismissed the case for failure to establish probable cause for violation of the said code. The information does not charge Kaliraya, but only private respondents in their capacity as incorporators or members of the board and corporate officers. There is nothing in the record that directly links the respondents to the purported violation. So, the liability of Carreño being corporate officers of Kaliraya corporations, even if they are the officers, the corporate officers of the Kaliraya corporation, that is not enough to hold them criminally liable. Okay. Corporate agents are not personally liable for violations of the corporations unless there is an allegation in the information that they willfully and knowingly vote for or assent to a patently unlawful act, or they are guilty of gross negligence or bad faith. So, ang liability ng corporate officer hinges on their active participation. That was the earlier ruling of People versus Temporada. So, pag active participation, you had an active participation, magiging liable ka for corporate liability or for liability of the corporation. Since Carreño et al. Did not personally participate in the act of the non-registration or the untruthful statement and the registration statement, they are not liable. Okay? So Supreme Court said that even the Securities Regulation Code recognizes this limited culpability by only imposing a penalty on officers of the corporations who are responsible for the violation. So only officers of the corporations who are personally liable. Sino yung personally liable? When those corporate officers actively participated in the act complained of. So, sila Carreño, being directors of the corporation, they were not the ones responsible for the untruthful statement and the registration statement filed before the Securities and Exchange Commission. So, unless they are directly responsible for failing to correct the registration statement, they cannot be held criminally liable for the act imputed against or imputed on them. So that's the rule. Now, in Valenzuela versus People, August 30, 2023, okay? Now, the president of a real estate company cannot be held liable for violation of PD 957. I think nasite ko na to doon sa una. Okay? Subdivision Condominium Buyer's Protective Degree. Because Valenzuela or the office of Valenzuela was not in charge with the registration of the condominium sales with the Register of Deeds. So, if you're not in charge, if you did not have participation in the act complained of, the mere fact that you are a corporate officer is not enough for you to be held criminally liable. What is crucial in ascertaining criminal liability in case of corporate officers is not the position of the said officer. So remember this. What Supreme Court said, what is crucial in ascertaining criminal liability is not the position of the officer, but his or her functions in relation to the specific violation he or she is charged with. Oh, ito pa. Magkakakonekta to. People versus E&D. Supply. January 24, 2024. Now, mere membership of the board in the board of directors or being a president per se does not mean knowledge, approval, and participation in the act alleged as criminal. In this case, I think this is the case of Dio. Dio was a corporate officer. Specifically, he was a treasurer of a corporation. Now, the corporation was charged for non-payment of taxes pursuant to the National Internal Revenue Code. So, the corporate officer at that time was DIO. Okay. Now, he was charged that he was the one responsible for the non-payment of taxes. But here, Supreme Court said that is not enough for corporate officer ka na liable ka na. It is required that the prosecution must prove the active participation of the accused in the non-payment of deficiency income tax and VAT, value-added tax. The prosecution failed to prove her role in the corporation when the crime was supposedly committed. The prosecution did not present proof to identify any of the officers of the corporation. So, doon lang, di ba, in the previous decisions, doon lang tayo nagpaikot-ikot whether the corporate officer actively participated in the act complained of. So, here in People versus A and D Part Supplying Inc., the fact that you are a member of the board of directors is not enough for you to be held criminally liable. Now we go to another subject, which is also a favorite bar exam questions: self-defense. Now, as you know, there are three elements of self-defense. One is unlawful aggression, whether it is actual or imminent. The number two, reasonable necessity of the means to repel the attack. And number three, that there is lack of provocation on the part of the person defending himself. Now, the most important element is unlawful aggression. So you have to determine whether at the time of the killing or the time of the act, there was an unlawful aggression. No unlawful aggression, no self-defense. That's the rule of thumb, ika nga. So, you have to ascertain whether or not there was unlawful aggression. If there is, there is self-defense. And vice versa. In People versus Guarin, this is an old case, 2020, that unlawful aggression is absent when the victim fell on the ground and was disarmed. So, the victim was the initial aggressor, and he was armed. But the moment that he was disarmed, it will no longer constitute unlawful aggression. There's no more unlawful aggression. So in other words, if unlawful aggression has already ceased, any killing done by the accused is no longer justifying. So there will be full criminal liability. When the accused was on his way to the store, Guarin saw the victim, who suddenly drew a knife and tried to stab him. During the attack, the accused was able to step back, thus the victim was not able to hit him. But for the second time, the victim tried to stab the accused. but the former fell on the ground. Nahulog, siguro nadulas. At this instance, the accused took the knife away from the victim and stabbed the latter using the same knife. There is no more unlawful aggression. The unlawful aggression ceased when the victim fell on the ground and the accused successfully disarmed him. So, Guarin is criminally liable. People versus Zapata, March 2021. Ito naman, si Guarin nadulas or nadapa. Si Zapata, in the case of Zapata, the attacker or the victim had been dispossessed of his weapon. Nagawan. The moment that the victim was dispossessed of his weapon, unlawful aggression has already ceased. There's no justification or there's no justified circumstance that can be invoked that on the part of the accused if he killed, for example, the victim. Even if it was the victim who initially attacked the accused and he was the initial aggressor, if his possession of the bolo he was dispossessed of a bolo, of a weapon, he could not be considered as an unlawful aggressor. Okay, you remember that. Still on self-defense and People versus Makaraig, September 7, 2022. Ito, hindi pa ito tinatanong sa bar exam. Whether or not verbal aggression can be considered as an unlawful aggression. Kunyari, minura ka. Okay? In this case, the perceived aggression that the victim exhibited was verbal when he said, tapusin na natin to. O yan, di ba? Pag sinabi, sige, tapusin mo na yan. Ibig sabihin, patayin mo na yan. Is that an unlawful aggression? The Supreme Court said, no. Verbal aggression is not unlawful aggression, even conceding that the fact that the victim verbally harassed the accused. There was no reasonable necessity of the means employed by the accused to prevent or repel the aggression. His act of drawing his loaded gun was not proportionate to the alleged verbal aggression on the part of the victim. Okay ba? Ito, Abuyo versus People. You read this case, July 26, 2022. It is settled that, for example, the victim was armed with a bolo and he momentarily lost possession of his bolo or weapon, or he was dispossessed of his weapon. The rule is, there is no unlawful aggression to speak of, but this is different. Aboyo lost momentarily of his bolo. He lost possession of his bolo, but he was able to recover it immediately. The Supreme Court said there was unlawful aggression. So even if he lost possession of his weapon, but if he recovered it immediately, there is a continuous unlawful aggression, or unlawful aggression did not cease when the victim regained possession of the knife. Ito important dito. This was written by Justice Mario Lopez. Camillo versus People, February 8, 2023. Medyo, nasa borderline ika nga whether there was unlawful aggression or not. So, kailangan nating himayin if this will be asked. While Camillo was carrying a sack of rice, the victim suddenly boxed him. The victim, at that time, the victim was drunk. Now, Camillo did not mind the victim, even if he was boxed by the victim. He continued working. But for the second time, the victim boxed him again. Nakakaano na to, nakakadalwa ka na. This time, Camillo put down the sack of rice and punched the victim's nose and jaw. And medyo napalakas ata pagkakasuntok. The victim fell down, hitting the concrete pavement, which led to his death. So, malakas ang pagkakasuntok dahil napanga, di ba? Nahulog, natumba, tumama siguro ang ulo sa semento, and the victim died. Now, the question is whether or not Camillo is criminally liable. Medyo borderline to. Without this case, siguro kayo, iba-iba ang ating interpretation. There was no more unlawful aggression or there was unlawful aggression. So, but the Supreme Court said there was still unlawful aggression. Okay. Unlawful aggression exists if persons invoking self-defense believe, paniniwala niya, in due exercise of their reason, that their lives or limbs are in danger. The guilt of the accused should depend upon the circumstances as they reasonably appear to the accused. That Supreme Court said that the unlawful aggression had not ceased when the accused put down the sack of rice. Because from the point of view of Camillo, there was still unlawful aggression which must be repelled. Which must be repelled. Okay. And di ba, there were two instances na sinuntok siya. The first, the second. So, even if yung una, tapos na, and the second time around, na sinuntok siya, that point in time, Supreme Court said there was still unlawful aggression. It was attested by the witnesses that the victim did not stop attacking the accused after the latter put down the first and the second sacks of rice. The victim was still in the fighting stance until he met the wrath of the accused defense. Okay. Insanity. So, insanity, in the case of People versus Panya, this is a 2020 and back. So, medyo luma-luma na siya. But I included this case in this lecture because it is a basis, preparatory, di ba? So, preliminary ika nga. So, I cannot discuss with you the prevailing jurisprudence unless di ko isasite si Panya. Because Panya is the prevailing rule now. Ang issue dito is how do you prove insanity? Yung mga naunang kaso, ang daming iba-ibang kaso na insanity can be proven by any person, any witness who is intimately related to the accused. Kunyari, kapamilya, nanay, tatay, kapatid. Di ba? Pwede siyang mag-prove na yung accused, yung kanilang kapatid, yung kanilang anak, yung kanyang tatay is insane. But under Panya, it has been settled that it must be medically proven. So, for you to invoke insanity, you have to present an expert. Ang expert naman dito is it's either mga psychologists, di ba? Yung mga doctors, di ba? Because they possess knowledge enough to establish that a person is really insane. So, in People versus Panya, the Supreme Court introduced a three-way test. Tatlo, mamamaraan in proving insanity. First, that insanity must be present at the time of the commission of the crime. So, that the accused was insane when he committed the crime. Pangalawa, or the second, that the insanity of the accused must be medically proven. And number three, that the effect of insanity is the inability to appreciate the nature and quality or wrongfulness of the act. So yung number two, medically proven. In this case of Panya, the accused was convicted because the only witness who testified on his insanity was the mother, yung nanay ng akusado. Supreme Court said that is not enough to establish insanity. Now, next is the case of Ragudo. Yan, 2024 na. Now, Sabi nga ni Panya, medically proven. But the problem in Ragudo, the medical report was, or the examination of the mental fitness of the accused was done more than 1 year after the killing. So, pwede ba? Even if, kunyari, last year pa siya na-charge ng crime, it is only now, a year after, that the medical examination on his mental condition was made or was conducted. Okay, anong sabi ng Supreme Court? The witnesses who were able to testify based on their personal knowledge on the appearance and condition of the accused show no manifestation or indication that he was insane. So insanity in Ragudo was not proven because although there is a medical examination report on his mental condition, that examination was conducted 1 year after the commission of the crime. That is enough. That is not to be considered. And the others who testified did not testify on the mental condition of the accused. So, ang kanilang testimony, the witnesses who were presented did not prove that the accused showed manifestation or condition or indication that he was insane at the time of the commission of the crime. Ito, napakagandang kaso, the case of Ruiz versus People. For the first time in history, that the Supreme Court applied the so-called Panya doctrine, the Panya test. Di ba kanina, na-cite ko yung 2020 case. So, in Ruiz versus People, the three-way test was applied. Okay? Anong nangyari sa Ruiz? Si Ruiz is isang babae na pinatay yung sarili niyang best friend na babae din. Si Ruiz na napaka-religyosa. Diba? Nagsisimba siya, palasimba, paladasal, palanovena. Yung kanyang best friend, kasama niya. The problem with Ruiz, nagda-diet siya. Nagdidieta. So yung pagdidieta niya, nadideprive yung kanyang brain ng mga nutrients na kailangan. Nagkaroon ng effect yun. Na-develop since na hindi siya kumakain siguro dahil siguro kumakain lang siya isang beses ang araw, nagkaroon ng effect sa brain niya. Isang araw, nadatnan nung tatay ni Ruiz. Hubot-hubad si Ruiz. Nasa ibabaw ng hubot-hubad na victim, yung kanyang friend. At duguan, patay, sinakal niya yung kanyang best friend. Nung madatnan nung tatay, when the father arrived, Ruiz's hand was inside the victim's mouth and shouting, "This is the New Jerusalem." Nung madatnan nung tatay, si Ruiz, hindi nakilala ni Ruiz yung tatay at nanlilisik yung mga mata. Di ba? Ito yan, nanlilisik yung mga mata. So sabi ng Korte Suprema, the first and third test were present. Ano ba yung first and third? Titingnan natin, babalik ko yung ating Ayan. The first test is that insanity was present at the time of the commission. The third test is insanity. The effect of insanity is the inability of the accused to appreciate the nature of his act. So, present daw yan, sabi ng Korte Suprema, because she failed to recognize her own father. And she even shouted back at him and kicked him when the father was trying to pull her hand out of the deceased's mouth. Okay? And this is further bolstered by the fact that the accused eyes were glaring, or in Tagalog, nanlilisik. So, first and third tests are present. Now, the number 2 test, that insanity must be medically proven. It was also complied because the prosecution presented 2 psychiatrists as expert witnesses. These 2 psychiatrists rendered the respective medical opinion. The first psychiatrist said that the accused suffered from psychosis even before the commission of the crime, while the second expert witness diagnosed her with paranoid type schizophrenia. So, nai-apply. So, insanity was applied. Ruiz was acquitted of the crime of homicide. The moral of the story is, kayong nagjejeta dyan, huwag niyong masyadong seryoso yung pagjejeta. Kasi si Ruiz nagjejeta, naging loka-loka siya. People versus Villa. Nasa insanity pa rin tayo. Ang issue lang dito whether Villa was insane at the time of the commission of the crime. Ang ginawa ni Villa rito, after niyang mapatay yung victim, siya mismo nagtangkang magpakamatay. Diba? So, pinatay niya yung victim. At nung ma-realize niyang patay na, siya mismo nagtangkang magpakamatay. Insane ba si Villa or not? Supreme Court said, no. The fact na one who attempted to commit suicide after the killing is not insanity. So, ibig sabihin, you're aware, di ba, yung number 3 test sa panya, that the effect of insanity is the inability of the accused to appreciate the wrongfulness of his act. So dito, alam mo na mali yung ginawa mo kasi ikaw mismo ay gustong magpakamatay, gustong mamatay. Ibig sabihin yan, you want to be, you do not want to be penalized. Ayaw mong makulong. That's why gusto mong magpakamatay. That act of attempting to commit suicide is indicative of his awareness of the gravity of his criminal actions. Ang dami natin insanity, ano? Sana may mark question dito. And the next is the case of People versus Calines, April 3, 2024. Anong nangyari naman dito kay Calines? Si Calines, ang sabi niya, nagdilim ang aking paningin. Nagdilim. Blackout. The fact that the accused blacked out at the time of the commission of the crime is not insanity. It was held, though that the accused claimed to have blacked out on the day in question, there was no showing that the same happened at the time of or immediately preceding the killing of the victim. All he said was he blacked out and was not sure whether it was he who killed the victim. That was the last case on insanity. So, ang dami natin insanity, siguro isa man lang dito ay pwedeng itanong. But yung Panya or Ruiz ang napaka-importanting kaso. Now, we go to another exempting circumstance. Diba? Insanity is the first and the second is minority. Minority. Under Republic Act 9344. Bakit tanong yan? Because, di ba yung na-remember niyo yung isang kaso sa Tagum City, yung isang UP Law student, babae, sinaksak ng 3 na minor de edad. Yung isa 17, yung isa 15, yung isa 14. So, bakit tanong? Mayroon bang criminal liability? Yung 17, yung 15, yung 14? Kailangan alam nyo the rules under Republic Act 9344 or Juvenile Justice Delinquency Act. Ano bang rule doon? Review. Below 15, no criminal liability. 15 or more but below 18, no criminal liability. But this time, in this age gap, you have to declare or to ascertain the existence of discernment. So 15, between the age gap, between 15 and 18, you have to determine discernment because that will it is important in determining criminal liability. So if the accused acted with discernment, there is criminal liability. No discernment, even if more than 15, less than 18, there is no criminal liability. But there is civil liability. The guardian or the parent will shoulder the civil liability. Now, in this case of CICL XXX versus People on decided March 14, 2023, en banc, hindi siya tinanong last year. Bakit tanong ngayon? This is en banc. Ang impact nito sa atin, mabigat because lahat ng previous rulings ng Supreme Court medyo nalinaw na. Because in this case, the Supreme Court laid down the rules on discernment. Medyo tandaan natin. Okay. At yung tatlong justices, Justice Gasmundo, Justice Singh, Justice Salameda, contributed their personal observations on the criminal responsibility of the CICL. Si CICL XXX ay 17 years old. Earlier, yung kanyang kabarangay, yung victim, si AAA, nag-testify against CICL, against those accused. Dahil yung akusado, he was charged before the lupon tagapagkasundo or the barangay conciliation system. Diba? Lupon tagapamayapa. I hope I got it correct. Nag-testify yung victim na itong si XXX ay siya yung nag-commit ng crime. Nagalit ngayon yung si XXX kay AAA. Nagalit. Isang gabi, may kasama si XXX. Inabangan niya yung victim doon sa harap ng bahay. At pinalo niya yung ulo ni AAA. So, madaling araw na, nung makita nung nanay, the mother of the victim saw the latter at duguan at halos lumuwa na yung mata. When the mother of the victim said, "Who did this to you?" Sabi ng victim, it was CICL XXX. Okay. Now, the 17-year-old accused was charged with homicide. Now, ang pinag-uusapan dito is discernment because 17 na siya, 17 years old. Now, was there discernment? Did the accused act with discernment? Yan ang titingnan natin. Supreme Court said yes, as indicated by the gruesome nature of the attack. Paano yung gruesome nature of the attack? Chief Justice Gasmundo said that there is discernment when he mauled the victim with a blunt object, which is hard enough to break a skull or shake a brain. Di ba? Hard object, siguro, 2x2 o tubo. According to Justice Singh, there is also discernment because the brain injuries of the victim palpably show the gruesome nature of the crime. Justice Salameda said the location of the wounds and the deliberateness of their infliction upon the victim demonstrate his discernment. Now, the second indicator of discernment is the circumstances showing the accused cunning and shrewdness. Cunning and shrewdness. Ano ba yung basihan ng Supreme Court in saying that there was cunning and shrewdness in the attack? The court took note that the accused perpetrated the attack in the early morning at around 3 o'clock while accompanied by a companion, that they waited for the victim to get home, and after striking the victim, they escaped before any witnesses could see them. Di ba? Third indicator, the attempt of the accused to silence the victim, or it is an act of retaliation because earlier, the victim testified against the accused doon sa barangay, lupon tagapagkasundo ba yun? Okay? Gustong gumante yung akusado doon sa victim kasi nagtestigo siya against him. And the fourth, that the accused quit school. Hindi na siya pumasok. Di ba? Parang flight to. Flight is an indication of guilt. And he fled to his home in Sagada Mountain Province. His overt acts of quitting school and returning home to Sagada are indicative of his awareness that what he did was wrong. Yan. We will leave minority because hindi lang naman siya ang subject natin. Another exempting circumstance is accident. Di ba? Accident. Paano siya nagiging accident? Pag walang if the accused exercised due care in committing the act, meron pa iingat, accident siya. The opposite of it is there is negligence. Di ba? There is negligence if you are not you did not exercise reasonable due care. Okay. Now, in People versus Liocado, the accused here was charged with rape with homicide. May nawawalang bata nakita sa bahay niya. The child, yung missing child, was discovered at Locado's residence. Nasa ilalim nasa tabi ng kanyang kama. So, circumstantial evidence was used in charging the accused, Lucado. Okay? Sabi niya, when the cadaver of the victim was found at his residence, at his house, sabi niya, it was a mere accident. Kumbaga, nasuntok kasi niya. Okay? He unconsciously boxed her on the chest after the victim abruptly awakened him. Kumbaga, he was not acting, there was no intent on his part to kill the victim. Kumbaga, he unconsciously boxed her nung magulantang siya. Ang sa Tagalog, natutulog siya, then he was abruptly awakened. Diba? So, nasuntok niya. It was a mere accident. Sabi ng Korte Suprema, that is not an accident. The act was not lawful. Yung pagkakasuntok mo, is it lawful? It was not. The act was not lawful when the accused was committing a crime, that he boxed the victim on the chest. At least, the crime is the act would constitute physical injuries. So, the accident was not present as the victim died due to asphyxia by suffocation. Yung medical reports, ang finding, siya ay in-strangled. Diba? Ng accused. So, the victim died to asphyxia by suffocation and was found underneath the bed with a cloth wrapped around her mouth and nose, and with both hands tied and twisted at her back. Those findings are not consistent with accident. The acts were committed deliberately or intentionally. So, hindi yan accident. Now, evident premeditation. So, anong element dito? The third element, that the accused, there was a lapse of time from the planning up to the execution, and that lapse of time would enable the accused to realize the consequences of his act. Yun ang third element. In the case of People versus Villa, the accused brought a gun to the scene of the crime. When he brought a gun to the scene of the crime, that is evident premeditation. So pinag-isipan mo, you carefully planned the execution of the crime. Bakit ka magdadala ng barel if wala kang intent to commit the crime? Di ba? So if you brought a gun to the scene of the crime, and that would indicate evident premeditation. So this is what happened in People versus Villa. That before he left his house in Quezon City for Manila, he already had in mind the intent to kill the victim. His plan to kill had already been planned as he carried with him a gun before going to the house of the victim's mother. Okay, that's the latest sa evident premeditation. What about treachery? Baka lumabas to. I posted this on my Facebook account. Pagdanganan et al. Versus People, November 13, 2023. The victim, the accused, together with his two friends, they were engaged in a drinking spree. Nag-iinuman sila. While they were already drunk, one of the victims biniro si pagdanganan. Sabi niya, ang pangit mo. Kamukha mo si Max Alvarado. Okay. Yung kanyang kainuman, biniro siya si pagdanganan ng ang pangit mo. No, personal na pikon si akusado. The accused the accused reacted to that. Okay? Nung siya biniro na siya pangit, nag-react siya. What he did was, he left. He went to his house. Yung kainuman niya, akala niya matutulog na siya because umuwi na siya. But unknown to the victims, pagdanganan, the accused, returned with a knife on his hand. He was holding a knife. And he suddenly attacked the victim. The act was so sudden. Now, is that enough to constitute treachery? Suddenness of the attack. Supreme Court said no. Even if the attack was sudden, there can be no treachery here. Because previous to the act, he was provoked. The accused was provoked by the victim that he was ugly. Treachery could be done on impulse as a reaction to an actual or imagined provocation offered by the victim. Provocation on the part of the victim negates the presence of treachery. So, bear this in mind, that if there is provocation earlier, if the accused was provoked by the victim, there can be no treachery even if the attack is sudden. Bakit kaya? Because the second element is not present. There are two elements of treachery. The first is the employment of the means and ways and method to attack to ensure the execution of an act and to prevent the victim from defending himself. And the second is the manner, the mode, the method of attack must be deliberately or consciously adopted. Dito, sa pagdanganan, wala yung second element. You could not say that there was an employment, that the means, the method of attack was deliberately or consciously adopted. Wala yun. Kaya that's why treachery cannot be appreciated in this case. Now, abuse of superior strength. May 27, 2024, People versus Cadorna. Okay? Ito, si Cadorna na charged, he was charged with the killing of a child. Nakita yung child, the child was earlier reported to be missing. Nakita to sa loob ng bahay ni Cadorna, hanging, nakabitin. So, sabi niya, since it was the house of Cadorna where the victim was found hanging, Cadorna was liable for the crime of murder. What is the qualifying circumstance? Abuse of superior strength daw. Or taking advantage of superior strength. So, since the victim was a minor, he was a child, and it would be easy for the accused to kill him since malaki yung akusado, maliit yung bata. There is a notorious disparity of the strength between the accused and the victim. And dalawa pa to, there was treachery also. The killing of a minor may also constitute treachery. Okay? The killing of a child falls under treachery. However, in this case, the court applied not treachery, but taking advantage of superior strength because parang na-absorb na siyang treachery ng abuse or the taking advantage of superior strength. So what is the moral of this story? Between treachery and abuse of superior strength, the latter prevails. Now, service of sentence under penalties. So after this, after book 1, we will have a break. So when we resume, we will discuss book 2. But I will just finish the slides for book 1, service of sentence. So one of the modes of extinguishing criminal liability under Article 89 is by serving the sentence. Di ba? Yung pagdudusahan mo na yung sentensya. Now, what is the effect of service of sentence? Pag natapos mo na siyang pag-serve, di ba? Na-serve mo na yung sentensya, ano na yung effect nun? Now, in the case of People versus Agustin et al., March 15, 2023, the Supreme Court said that upon service of sentence, the prisoner must be immediately released. The policy is to release detainees who have been imprisoned for a period equivalent or longer than the maximum imposable penalty. So, the Supreme Court cited the Mandela Rule. Siguro ito yung Nelson Mandela of South Africa. The purposes of a sentence of imprisonment or similar measures privative of person's liberty are to protect society against crime and to reduce recidivism. Those purposes can be achieved only if the period of imprisonment is used. So pag na-serve mo na yung sentensya, you must be immediately released. Now, prescription of crime. This is a 2025 ruling. I included this, the People versus Concebido. Because in 2023, there is a case of People versus Corpus. Pag tinanong kayo sa Corpus, wala na po yun. The case of People versus Corpus and Republic versus the other case is Republic versus, I just forgot the title, was already abandoned by the Supreme Court. Ano ba yung People versus Corpus? Ang People versus Corpus, if the crime or the case falls under the rules on summary procedure under BP 129, the filing of a complaint with the prosecutor's office does not toll the running of the prescriptive period. Sa prescription kasi as a mode of extinguishing criminal liability, mayroong mga factors to be considered. One, ano yung period of prescription of crime? It depends on the penalty, if it is a light, a correctional, or afflictive, or a capital offense. So, nagbavari ang period of yung years of prescription. Number 2, kailan natutol ang running? Kailan na-stop ang running? So, iba-iba kasi yung rules nun. Depende kung it is a violation of the revised penal code or special penal laws. So, nasambit doon sa mga previous ruling na pag na-file ang complaint sa prosecutor's office, na-stop na yung running. The counting of the prescriptive period is stalled or suspended when a complaint is filed before the prosecutor's office for preliminary investigation. Nagkaroon ng butas or exception in People versus Corpus. Yung isa pala, Republic versus Desierto, na pag magfo-fall ang kaso sa rules on summary procedure, okay, na total lang ang running under BP 129 if the information is filed with the court. So, by express provision. Remember, BP 129 is a substantive law. Pag na-file lang ang information sa court, saka siya matutol. That's why in People versus Corpus, since it was covered, ang kaso doon is slight physical injuries. Since it is covered by the rules on summary procedure, the filing of the complaint with the prosecutor office does not toll the running. So, continue ang pagdano kung inabot ng matagal na panahon ng fiscal office na nag-conduct ng PI, so doon sa fiscal office, matatapos na yung prescriptive period. So, mag-expire na. But, in People versus Concebido, sabi niya, kawawa naman ng mga fiscals, kung sakaling mag-lapse yung period na habang pending sa'yo, baka mademanda ka ng dereliction dahil bakit mo hinayaan na mag-expire. So, take note that ang period ng arresto minor is only, ang prescriptive period is only 60 days. O kung ipinali yan sa'yo on the 50th day, so you have only 10 days to resolve. Mahirap yon. The ruling in People versus Corpus was reversed by the Supreme Court in People versus Concebido, April 2, 2025, that the prescriptive period for crimes is told upon the filing of the complaint with the prosecutor's office and the start of summary or preliminary investigation. So settled na siya. Whether it is covered by the rules on summary procedure or not, the filing of the complaint before the Department of Justice will toll the running of the prescriptive period. And the last slide is the case of People versus Kausing. Si Kausing, dati siyang lawyer na na-disbar ng Supreme Court. So, ang charge dito sa kanya is cyber libel. So, this case of Kausing versus People, October 11, 2023, settled whether the issue that in case of libel or cyber libel, ilang years o ano yung prescriptive period. Sa libel kasi, that's only 1 year. Does it include cyber libel? O yung kaso ni yung Rappler na reporter, di ba? Nung pinailan siya, sabi ng cyber libel, sabi daw ng RTC 15 years because it is punishable by pression mayor. Pero this Kausing case settled the issue that for libel or cyber libel, the prescriptive period is only 1 year because libel and cyber libel are not different. They are not, parang hindi magkaiba siya because cyber libel is a form of libel under the revised penal code. So that is settled na 1 year lang. So we'll have a break and when we return, I will discuss Book 2 of the revised penal code.
Why Central Books?
Because it's the home of the best legal minds. Central Books has always been a good friend.
Shows that because it's the best bookstore here in the Philippines. No one else.
Of course, the Central Books na magandang policy.
With so many authors, with so many books that are being printed day in and day out. It has, I think, the state-of-the-art machines that can really, transform all of these books very fast.
So I want to be part of that home of the best legal minds.
Central has been very accommodate, being very flexible in terms of discussing with the arrangements and all throughout the process. So
that is the reason why it's really privileged to become the author of this Central Books.
Central Bookstore was able to establish a name in getting authors who are basically experts on their fields.
Well, they share the same passion as me, and they believe likewise in providing accessible quality education to examinees, students, examinees, and they have produced so many authors.
Central Books is always ahead, up to date, hands-on, and very accessible to the authors.
Hands-on kayo. And you reach out to the lawyers, to the authors, and yung encouragement, and yung support, nandun talaga yung support.
Central Books really gave us the platform and opportunity to help the law students, to bring out the materials for them, and encourage nila yung authors nila to create books for the students. So that's why I think Central Books is a great avenue for law practitioners, for lawyers, for judges to share knowledge to law students, even to members of the market.
It's just CBSI #1.
Now, this is the second part of our lecture, Book 2 of the Revised Penal Code. So this pertains to specific felonies of the Revised Penal Code. So what are the recent jurisprudence, recent decisions sa Book 2 of the Revised Penal Code? So we have the case of Pablo versus People on direct assault. So dito, last year pala, mayroong isang bar question yung, I think, the case of Balsamo versus People, direct assault yun. So there is, the bar examinees were required to determine the proper crime, whether it is direct assault or serious disobedience or resistance under Article 151. Now you have to know what is the basis for the distinction between direct assault and resistance under Article 151. In Pablo versus People, the act of pointing a gun will constitute serious intimidation. If there is serious intimidation, it is always direct assault. So, in the case of Nojara versus People, a 2020 ruling of the Supreme Court, if the mode of committing the crime is there is force, when the offender uses force to attack a person in authority or agent of person authority, you have to know whether that force is serious or grave. If it is serious or grave, then it is direct assault. If it's not serious, that is a crime of resistance. But if it is serious intimidation, you don't have to distinguish whether it is direct assault or serious disobedience or resistance. It is always direct assault. In Pablo versus People, the act of pointing a gun constitutes serious intimidation. Ito yung taxi driver na when he was accosted by the two traffic enforcers in Marikina, and the enforcers were demanding for his license, ang nilabas niya is yung baril. At sabi niya, subukan nyo magkakaputukan tayo. That is serious intimidation, direct assault. Now, ito yung bar question last year, Balsamo versus People. Ano bang ginawa dito? Ang Balsamo versus People, you have to ascertain whether what is the intent of the offender. If the intent is to assault, that is direct assault. But if the intent is to defy the arrest, that is resistance or disobedience under 151. So, hindi na itatanong to, no? Hindi na itatanong kasi tinanong na siya last year. In Batumbakal versus People, in falsification of public document, the prescription of falsification of public document starts from the registration of the public document. If it is a public document, just like a birth certificate, death certificate, or a title of OCT, original certificate of title, paglupa, or TCT, ang prescription will start from the registration of the public document. May exception dito sa bigamy. Ang registration ng marriage contract sa civil registrar, hindi ang registration of the marriage contract, that is not the reckoning point. Ang reckoning point sa bigamy is from the discovery of the subsequent marriage. Usurpation of function. Napakagandang kaso si Piquero versus People. Si Piquero falsely represented as a lawyer. So sabi ni Piquero, I am a lawyer, when in fact he is not. And he used a fictitious name. He used the name of attorney Nojara. Attorney Nojara, I think Frondito, if I'm not mistaken. Attorney Nojara, and I am a lawyer. So meron sa mga nabiktima ng mga clients. And hindi naman pala sila lawyer. He was accused of usurpation of function and use of fictitious name. So sabi ng Supreme Court, there is no crime of usurpation of function if ang nirepresent niya or ang kinlaim niya that he is a lawyer. A lawyer is not a person of authority. So for purposes of Article 178 of the Revised Penal Code on usurpation of function, a lawyer is not a person of authority. So ang person of authority dyan refers lang doon sa tao, he is a person who is directly vested with jurisdiction. That's like a judge, a prosecutor, a barangay captain, a mayor. So pag a lawyer, there's no usurpation of function. Because a lawyer is not deemed a person in authority within the meaning of Article 177. I'm sorry, that's 177, not 178. Now, the proper crime committed by Piquero was use of fictitious name. Ito yan. Ayan. Use of fictitious name. So, ang element yan is you are using a fictitious name. And if the purpose of which is to, there will be public or damage to public interest or public damage. So, if you use a fictitious name and the resulting effect is there is damage to public. Dito, may mga naloko siya na clients. So, he was not a lawyer. So, nagpakilala siya na siya si Attorney Ipaprodito Nojara. Okay. But that is not a fictitious name. That is a real name. The problem is, patay na si Attorney Nojara. So, ang ginawa ni Piquero, nagkunyari siya si Attorney Ipaprodito Nojara. But that is not a fictitious name because mayroon talagang pangalan na ganon. But even if it is not a fictitious name, since nagpakilala ka na ikaw si Attorney Ipaprodito Nojara, the Supreme Court said that is a crime of using fictitious name under Article 177 of the Revised Penal Code. 178 na. 178. Okay. Illegal possession of treasury notes. Mayroong bago, Galliano versus People, Feb 2024. So, Galliano, tumaya siya ng loto. Ang ginamit niya, 1,000 peso bill. So, walang panukle yung loto outlet. Sabi niya, wala ka bang barya? So, sabi niya, wala po. That is the only money I have. So, sabi niya, sige, pabarya. So, bumalik siya after a while, hindi pa rin nabaryahan. So, ginamit niya the same 1,000 peso bill. Nagduda yung attendant, yung sa Lotto outlet, at tiningnan kung fake ba yun. So, it was a fake. It was a fake 1,000 peso bill. So, Galliano was prosecuted for illegal possession of treasury notes. Supreme Court said there is no crime or Galliano did not commit this crime because he had no intent to commit the crime. Mere possession of fake treasury notes, just like 1,000 peso bill, is not the crime if the offender did not have the mens rea or the intent. Okay? He had no intent to possess the same. His act of returning to the outlet and handing over the fake money was not attended with malicious intent. He harbored no criminal intent when he returned to the outlet. So, para bang bumalik ka pa nga, kung alam mong peke yun, hindi ka na babalik at tatakas ka na kasi nga peke yung pera. Perjury, bago to, kay the famous one, Attorney Larry Gadon. Now, Attorney Gadon filed a complaint for impeachment complaint against former Justice Sereno. And that complaint was filed before the Congress. Now, in the verification of that petition, he said that all the allegations in the complaint are true and correct based on his personal knowledge. So, doon sa verification, based on personal knowledge, sabi niya, but it was found out that those allegations were taken from news reports sa dyaryo, sa TV. So, hindi siya personal knowledge. So, sabi, may perjury ba sa false verification? That, in this case, sabi ng Supreme Court, that is perjury. Because, hindi naman galing sa kanya yung mga allegations sa complaint or impeachment. Now, rendering unjust judgment, February 17, 2024, Muhammad versus the Office of the Secretary of Department of Justice. So, ang rendering unjust judgment under Article 204 of the Revised Penal Code, kailangan prior conviction. Di ba? Kailangan may conviction or termination of the criminal of the case. Or of the case, ano? Pag hindi pa na-convict ang tao, hindi kailangan ma-file ng rendering unjust judgment. So kailangan mo muna i-exhaust yung remedies, okay? So kailangan mo nang matapos, okay? So that you can now file a complaint for rendering unjust judgment under Article 204. Okay. Now, bribery, yung People versus Nicolas, yung kanina, no? Yung conspiracy, okay? Yung act of facilitating the dismissal of criminal complaint is unjust act. Nililinaw ko to. Kasi there are three kinds of direct bribery under Article 210. Yung first is when there is an agreement between the bribe giver and bribe receiver, where the public officer will perform a criminal act in consideration of a price, reward, or money. So sa first mode, it must be a crime to be performed by the public officer. Sa pangalawa po, when there is acceptance of the money and the act to be performed by the public officer is not a crime, ang tawag unjust act. In People versus Nicolas, si Nicolas, ombudsman investigator na naka-assign, he was handling a case involving a mayor in Pangasinan. Now, he was approached by yung siguro emisary ng mayor na pwede bang i-dismiss natin yung kaso. Okay? So, nilalakad nila yung kaso kay Attorney Nicolas ng ombudsman. So, what kind of bribery is that? Yung pang pag-dismiss ng kaso, is it a crime on the part of the ombudsman investigator or a mere unjust act? So, you have to ascertain whether it is a crime or unjust act. Kasi hindi pwedeng, ang unjust act nandun sa first mode, hindi magkakaroon ng direct bribery. So, ang unjust act must fall doon sa second mode. Kailan nako-consummate? When there's an actual acceptance of money or a gift. So, nako-consummate yun pag tumanggap ng pera yung public officer at ang ipe-perform niya is unjust act. So, it is not a crime. So, kasi, bakit hindi siya crime? Bakit? Is it a crime if for example, the investigator, the ombudsman investigator will dismiss the case? Hindi siya crime. Kasi malay mo, totoo naman or meritorious naman na dapat i-dismiss yung case. So it is not a crime, but it is an unjust act. In Remolano versus People, direct bribery pa rin, the crime of direct bribery is not covered by the indictment for the crime of bribery. ito luma, tinanong na to sa bar. Oh, there's a distinction between robbery and bribery. So, ang direct bribery, it is mutual. Di ba? Mutual, may usapan. The bribe giver will give, there's an agreement, he will propose, pwede bang ayusin natin to. And the public officer will concur or will consent. So there is an agreement, mutual, di ba? Mutual agreement. In robbery, it is not mutual, it is involuntary. So, sasabihin lang ng, kunyari, pulis, hinuli kita. Ako pulis. Kung di mo regluhin to, papailan kita ng kaso, tutuluyan kita. That is intimidation that will constitute robbery. So, pag involuntary or not mutual, that is robbery. Pag mutual, may agreement, that is direct bribery. And puro ganon versus people. Actual acceptance is required in second form. So sinabi ko na, there are 3 kinds of direct bribery. So yung second form requires actual acceptance of a gift. So pag sinabing actual, hindi siya constructive. Mayroon bang distinction ng actual sa constructive acceptance? Meron po. Ang actual acceptance, kunyari, pera ang pinag-uusapan o pera. O kailangan yung pera ibigay. If, for example, kunyari lang, magbibigyan kita ng kotse worth 1 million. So, kotse ang pinag-usapan. Kotse. Ang binigay sa iyo, susi. Ito na yung susi ng kotse mo. O tinanggap yung susi. But, nagkaroon siya nakonsensya siya later, sinauli niya yung susi. O hindi niya tinanggap yung kotse, hindi niya kinuha yung kotse. So, binalik niya yung susi. Mayroon bang actual acceptance? Wala. Kasi, there is only a constructive acceptance ng kotse that is not required. Hindi yan contemplated ng direct bribery doon sa second form. People versus rapal in malversation. Okay? In malversation, this crime is committed by a public officer and he is an accountable one. Do not forget the element of accountable public officer. Pag public officer lang, but hindi siya accountable, there's malversation. So, kinakailangan, he is an accountable public officer. So, a municipal mayor who received disbursements of public funds in the form of cash advances for intelligence and confidential funds. He is an accountable public officer. Kailangan, when do we say that he is an accountable public officer? Madali lang po yan, jurisprudence. When a public officer receives public fund or property and he is bound to account for it. Nagiging accountable public officer na siya. Pag tinanggap niya yung pera galing sa yung public fund or property at kailangan mong i-account yan later, magkakaroon ka ng accounting, or you are now an accountable public officer. So in people versus rapal, pag ikaw mayor, tumanggap ka ng confidential fund, accountable public officer ka na pag ginastos mo yun, patay ka ng malversation. The same is true with in the case of Zuniga versus people. Yung clerk of court, di ba, sa RTC, MTC, pag ikaw ay nakadispalko ng isang property o public fund or property na natanggap mo because you are a clerk of court, you are supposed to be the custodian of all courts, funds, revenues, and properties. You are liable for malversation. Now, people versus Reales, tandaan nyo to, January 22, 2024, malversation ulit. In people versus Reales, it was held by the Supreme Court that absence of demand does not create the presumption of malversation. So, balikan natin. Sa malversation, hindi kinakailangan, it is not necessary for the prosecution to prove how the offender misappropriated the public fund or property. Hindi niya kailangan i-prove na pinangbili na niya ng bahay lang. Di ba? When he purchased land, he used a public fund. That is not required. Ang kailangan lang is presumption of malversation. But the question is, when do you establish the presumption of malversation? So, ang presumption of malversation is created when the accountable public officers fails to account the money or public property that he received at the time of examination. Kunyari, nagkaroon ng spot audit. Sabi ng auditor, oh, sir, you are short of 10,000 pesos. If you fail to produce or to account 10,000 pesos, there arises a presumption of malversation. That presumption of malversation is enough to indict the crime of malversation. And if it is unrebutted by the offender, it is enough to convict. Okay, di ba? So, pero paano magka-create ng presumption? There must be a demand first. A demand, sir, you are short of 10,000 pesos. Where is this 10,000 pesos now? Nasaan na to? O hindi mo ma-produce? There is now a presumption of malversation. But it does not mean that if there's no demand, there's no malversation. Ang kinakailangan lang demand is for the purpose of creating the presumption. So, mapuprove ang malversation even without that presumption. So, even assuming there's no demand, sasabihin, there's no crime of malversation. Wrong. There's still malversation because malversation can still be proven even without the presumption. Okay? The absence of demand, it does not necessarily mean there is no crime of malversation. Kinakailangan lang demand in order to establish the presumption of malversation. Now, infidelity in the custody of prisoner under Article 223 of the Revised Penal Code, di siya lumabas last year. Pwede siyang lumabas ngayon. Tingnan nyo ang date, March 27, 2023. There are two kinds of infidelity in the custody of prisoner. One is found in 223 by consenting or conniving with the escape of the prisoner. Diba? Itong mga krimen na to nakukumit to ng mga jail wardens, jail guards, and police officers who have custody of the prisoner. The other one is 224, evasion through negligence. Ito yung, there is negligence on the part of the jail guard. Dito sa Pineda, there is a question whether the proper crime committed by Pineda would fall under Article 223 or 224. Chinarge siya ng 223. Consenting to or conniving with. But later, after trial, it was found that he was negligent. Bakit siya negligent? Because Pineda was tasked to accompany a prisoner for medical checkup, while the inmate was undergoing a medical examination. Lumabas si Pineda. Nakatakas yung preso. Lumabas, siguro bumili ng sigarilyo. Sabi ng trial court, no, the proper crime should have been Article 224, that is evasion through negligence. The question is, can the court now convict the accused who was originally charged for violation of Article 223? Now, the Supreme Court said no. That would be in violation of his right to be informed of the nature and cause of accusation against him that is guaranteed by the Bill of Rights of the Constitution. Di pwede. Because the elements of 223 and elements of 224 are different. The variance doctrine will not apply. Another case is the case of Basig versus People. Si Basig was a personnel of Bureau of Jail Management and Penology. One day, he accompanied, I think, 4 or 5 inmates. While the inmates were, 4. While the inmates were inside the courtroom, the session had not yet started, the POW lawyer asked Basig to remove the handcuffs of the detainees. And Basig acceded to the request of POW lawyer. Now, he went outside the courtroom. 1 or 2 of the detainees escaped. Was Basig negligent? The Supreme Court said yes. Supreme Court said the courtroom is not a jail facility where there are several jail guards. Since this is a courtroom with no other guards present, you are not supposed to leave the detainees inside the courtroom. if they escape, who will run after them? That is logical. So therefore, you are liable under Article 224. Parricide. People versus Tanaraj. Para siyang Bombay. July 29, 2024. Si Tanaraj is a wife. Babae siya. May asawa siya, siyempre. Yung asawa niya, pag nag-aaway sila, if they had a quarrel, palagi siyang nagsasabi, hihiwalayan kita. Oh no. Pag nag-aaway sila, sinasabi ni Tanaraj, iiwanan kita. Si lalaki, huwag mo akong iiwanan. Kasi mahal kita. Now, isang araw, isang gabi, nag-away sila ng matindi. At nauwi yun sa pagpatay. Si Tanaraj, na charge ng parricide, allegedly, sinaksak niya yung kanyang asawang lalaki sa leeg. Okay? Dinala ni Tanaraj yung kanyang asawa sa ospital, but namatay din. Now, liable ba si Tanaraj ng parricide? The Supreme Court acquitted her. In the crime of parricide, the mens rea of the accused must be established by the prosecution. The prosecution failed that there was criminal intent on the part of the accused to kill her husband. It was, the Supreme Court concluded or observed that the victim committed suicide. He killed himself because Tanaraj wanted to abandon him. Pero hindi ako naniniwala dito. Magpapakamatay ka sa leeg? No, parang hindi ata kapanipaniwal. But sabi ng Supreme Court, hindi naman tayo Supreme Court, that the victim committed suicide because there were previous incidents na pag nag-aaway sila at iiwanan na ni Tanaraj yung asawa, magsasabi yung asawa na magpapakamatay siya. So, na-acquit si Tanaraj. Murder, in the case of People versus Camarsi, at I think binigay ito sa bar exam. Binigay ba? Mukhang hindi. Ang kaso ni Camarsi, there was a question whether to convict him of murder and arson. Okay? Kasi maraming estudyante o bar examinees, pagdating sa arson with homicide, kinakabahan na sila. Hindi nila alam yung rules. So, ang Camarsi, nag-check-in sa motel. Kasama niya yung kanyang girlfriend. After several hours, lumabas si Camarsi, sumakay sa sasakyan at humarurot. At sinigawan niya yung roomboy, may sunog. So, biglang tumakbo yung roomboy sa kwarto, nakita niya nasusunog na yung mga kortina. At yung bangkay ng babae, andun sa lapag, may mga saksak. Sinaksak. At sinunog yung bangkay. So, ano bang crime ni Camarsi? Is it arson with homicide? Is it murder? Yung bang pagkakasunog, anong effect? So if there is a use of fire in committing the killing, that will be murder kasi qualified sa ng use of fire. But the Supreme Court did not apply that qualifying circumstance. Although sunog, sabi niya, hindi naman namatay siya sa sunog. The victim died due to stab wounds. Pero sinunog siya. Anong effect ng pagkakasunog? Supreme Court said, it is an act of cruelty by scoffing at the cadaver of the victim. That is cruelty under number 21 yan, number 21 aggravating circumstance under Article 14 of the Revised Penal Code. So there were two crimes. One, destructive arson. Kasi hotel is under yan sa pag sinunog mo yung building na kunyari hotel, destructive arson yan under Article 320 of the Revised Penal Code. At yung pagkakapatay is murder qualified by scoffing at the dead body of the victim. Intentional abortion, February 13, 2023. Ano ba to? Si Bakay, boyfriend siya. Meron siyang girlfriend. Nabuntis niya. One day, sabi niya, buntis po ako. Tapos sasabihin ng Bakay, sinong ama? Hindi kasali yun. So, sabi, humihilab yung aking tiyan. Si Bakay, merong hidden agenda na hindi siya ready, ayaw niya ng responsibilidad, pinainom niya yung kanyang girlfriend ng isang gamot, ang sabi, pampakapit. That it was a vitamin intended na maging nakapit yung yung bata sa uterus. At binigyan din siya ng herbal drink to relieve the victim of abdominal pain. Unknown to the victim, it was an abortifacient, pampalaglag. Siguro saan kaya ito nakabili? Anong crime ni Bakay? Supreme Court said that is intentional abortion under Article 256 of the Revised Penal Code. Even if there is no violence committed, intentional abortion is committed when the offender employed deceptive action upon the pregnant woman by giving her tablets, misrepresenting them as vitamins. In slight physical injuries, the recent is Cafranca versus People, May 15, 2024. Basahin nyo to, mga nakikinig sa aking lecture ngayon. Kasi napakagandang decision. Si Cafranca, isa siyang babae na nakapatay ng isang matanda, septuagenarian. Okay? Yung matanda, sa isang, siguro parang apartment, nagre-reklamo ng ingay. Maingay. Kasi gabi na, mayroon pang nagkakantahan doon sa baba. Tapos, yung aso ni Cafranca maingay. The noise created by the dogs, na they were barking. Nagalit si Cafranca, nagalit yung matanda, sinugod si Cafranca. Sabi niya, hoy, yung mga aso mo. Ang ingay. So nagkaroon ng exchange of invectives. At nasabi ni Cafranca, ikaw ang matandang walang pinagkatandaan. Na kumuha si Cafranca ng isang plastic na upuan at akmang hahambalusin si matanda. Out of fear, inatake yung matanda ng heart attack at namatay siya. The Supreme Court was confronted, anong crime ang nakomit ni Cafranca? Kasi chinarge siya ng homicide, that the cause of the death of the victim was due to the act of Cafranca in attempting to hit the victim with a chair, or whether it is a case of physical injuries, yung maltreatment under Article 266, paragraph 3, maltreatment or ill-treatment. So, yung bang was the utterance of ikaw ang matandang walang pinagkatandaan, ill-treatment or maltreatment under Article 266? Supreme Court said, no. Ang maltreatment or ill-treatment, there must be some act constituting injury. Kailan mo sampalin, suntukin. Okay? Pero ang problema, walang affecting injury. Kunyari, namula lang. Walang injury doon. Namula lang yung mukha mo sa pagkakasampal. That is ill-treatment. The use of impolite and disrespectful language is not ill-treatment or maltreatment. In the crime of maltreatment, there must be some kind of injury na mag-result sa victim. Okay. Ito, I will skip this. Now, in rape, hindi pa tinatanong People versus Agaw, October 2022. Yung, kailan nagkakaroon ng consummated rape? So the doctrine enunciated in People versus Kampuhan, a 1996 ruling of the Supreme Court, wala na po siya. Abandoned na po. There's now a new ruling or doctrine on how to determine consummated rape in the case of People versus Agaw. Doon sa luma, People versus Kampuhan, there's consummated rape if the touching of the penis is on the labia majora. Okay? Ngayon, hindi na po labia majora ang ating tinitingnan. In order to have a consummated rape, there must be touching or at least slightest penetration on the pudendal cleft of the woman. So, pudendal or vulval cleft, yun na po. If the touching is on the labia, that is a attempted rape only. So, People versus Triple X, 69-year-old woman was roused from her sleep when the accused 50-year-old woman, who was her brother-in-law, entered her room. He twisted her arm, causing her bolo to fall. That is rape. Okay? That is the Supreme Court took note of the medical report which showed the presence of spermatozoa, which is consistent with previous sexual intercourse. In People versus Triple D, in Bank 2022, the accused was convicted even if the victim did not testify. The prosecution only relied on the DNA test. The accused was the father of the victim and he impregnated the victim. Nagkaroon sila ng anak. Now, samples were taken from the accused, from the victim, and from the child. And naging, the result, the probability was 99.99%. So, there's no question that the victim, that the accused was the father of the child. So, siya. So, the first time in People versus Triple B, the Supreme Court used the doctrine of unavailable child doctrine. Meaning, even if the victim did not testify, even if the victim, the prosecution only used her affidavit, that will not constitute hearsay evidence. Now, People versus Triple C, one charged with statutory rape may be convicted of acts of lasciviousness. Dito, hindi na-prove whether there was touching. Okay? So, based on the testimony of the victim, who was only 8 years old, it was established that the accused committed acts of lasciviousness in relation to Section 5B as he lay on top of her in a certain space in her buttocks. So, it will not constitute rape because wala naman touching doon sa genitalia. And People versus Disipulo, rape by sexual assault is not a continuing crime. So if there are 3 acts of constituting sexual assault, there will be 3 crimes. Si Disipulo was charged with rape by sexual assault and rape by sexual intercourse. Sabi niya doon sa nanay ng victim, ate, ang ganda ng anak mo, 18 years old siya, pwede siyang maging model. Sabi niya, kaso lang problema niya, flat ang kanyang chest. So may kakilala po ako na pwede natin makatulong na para lumaki ang kanyang breast. Instead of bringing him to that person, Disipulo brought the victim to a hotel. Ni-rape niya. After the rape, while the victim was taking a shower, he inserted his finger inside the vagina of the victim. Then he brought the victim to the bed. While they were lying, he inserted again his finger. After inserting his finger, he took his cell phone, opened the camera, and he pushed the victim's mouth to his penis. While the victim was, while his penis was inside the victim's mouth, he took a video of it. Now, how many crimes were committed? Disipulo committed rape by sexual intercourse and 3 counts of rape by sexual assault. 1, by inserting his finger while inside the shower. 2, by inserting again while laying in bed. And 2, by inserting his penis inside the victim's mouth. So, if the victim is minor, two laws are violated, rape and Republic Act 7610. Dito sa lascivious conduct, it is not rape. Siyempre, ang rape under Article 266, that's A. Yung 14-year-old girl was raped by the accused. After having sexual intercourse with the victim, he inserted his finger inside her vagina. So there are two crimes committed, rape by sexual intercourse. However, since minor ang involved, hindi magiging rape by sexual assault yun. Kasi the provisions of Section 5B of RA 7610, yung child abuse will apply. So pag more than 12, pero ngayon 16 na, no? 16 na ngayon under the new law. Pag more than 12, less than 18, ang victim, whether it is by inserting a finger or by touching, the crime is lascivious conduct. Tatandaan niyo yan, ha? Pag more than 12, less than 18, whether it's by touching or inserting, lascivious conduct. Pero pag bumaba na ng 12, if it is by touching, acts of lasciviousness in relation to Section 5B, ang crime. If it is by inserting a finger, ang crime is sexual assault in relation to Section 5B of the revised of RA 7610. People versus triple X. Again, the offense of lascivious conduct has no reference to the revised penal code. Ibang-iba siya sa acts of lasciviousness under Article 336. Iba yung elements, iba yung concept ng lascivious conduct sa acts of lasciviousness. Ang lascivious conduct kasi, that is a unique crime that is found only sa Republic Act 7610. In fact, the law does not define what is a lascivious conduct, but doon sa implementing rules and regulations, sinabi doon that lascivious conduct is either intentional touching or introduction of an object. It has no reference at all to the revised penal code. People versus Hernandez. Rape by means of inducement. In this case, Anyunuevo met the victim. Si Anyunuevo, babae siya. Okay? He is, or she is, she has common, she is living with Hernandez. They live together or live-in partner. Okay? Mag-live-in si Hernandez saka si Anyunuevo. Now, yung babae, si Anyunuevo, invited the victim to clean her house for a fee. Now, nung gabi, doon natulog si victim, Anyunuevo and her live-in partner slept in a papag. So, silang tatlo nasa papag. Now, the woman, Anyunuevo, woke the victim up and told her that Hernandez wanted to have sex with her. When the minor refused, Anyunuevo threatened the former with bodily harm to coerce her into indulging in sexual intercourse. So, ano yung liability ng babae? Na ni-rape ng kanyang live-in partner yung victim. Okay? Ano ba siya? Principal by inducement or principal by, or is she liable for the rape even if hindi naman siya ng rape? Ang sabi ng Korte Suprema, yes. The phrase induce to indulge in sexual abuse as appearing in the information is enough, broad enough to cover the criminal act of having or committing carnal knowledge. So, hindi siya principal by inducement, but he is a principal by direct participation. So, because of conspiracy between Anyunuevo and Hernandez, the act of Hernandez and raping the victim is also the act of Anyunuevo. Siguro i-discuss ko to. Si People versus Triple Z. Meron kasing concept sa revised penal code, yung resistance. Pag meron bang resistance, rape ba? Or kung walang resistance ba, rape rin? So, is proof of resistance required? Okay. Dito, maraming decision dito in the past. Yung Chunlok case, 2017 case. Sa Chunlok, ang sinasabi doon, the proof of resistance must be, ano ang tawag dito? It must be, there must be a proof of resistance, sabi niya. In rape cases, there must be, kung ang resistance must be proven by the prosecution. If there is no resistance, there's no rape. If there is resistance, there is no rape. There is rape. Tama ba ako? May resistance, may rape. No resistance, no rape. I hope tama ko. Medyo yung Chunlok na yon, ano raw, parang lugi naman ng kababayan. Misogynistic. Di ba? Misogynistic daw yun. Misogyny. Pag iko-compel pa yung babae na mag-prove na she resisted the rape. Galit na galit dito si Justice Singh, the ponente of this case, in People versus Triple Z, that proof of resistance is not required if rape is committed by force, threat, or intimidation. Okay, so yan. So, yung Chunlok case, abandon na. If babasahin mo yung People versus Chunlok, a 2017 decision, ang resistance is something na material sa rape. But in People versus Triple Z, hindi ka na kailangan ang resistance. A mere attempt to resist is not the resistance required and expected of a woman defending her virtue, honor, and chastity. The resistance requirement compels a woman to risk her life to protect her virtue, honor, and chastity, as if a woman should believe that life is not worth living if she was abused without a fight. This view reeks of misogyny. Di ba? Okay? Trafficking under Republic Act 9208 in rape by sexual assault may coexist. Okay? So in the case of People versus Aras 2024 case, the testimony of the victim as well as the photographs she identified depicting that she performed oral sex established that sometime in 2013, the accused forcefully inserted his penis into her mouth. The act happened while he raped her for his customers' online viewing pleasure. So, naka-live or online yung camera, kinukunan ni Aras yung kanilang sexual activity. So, yun daw, the act of Aras constitutes two crime. Or, di ba? One is trafficking. Dahil ginagamit niya yung victim sa pagtatraffic. O meaning, yun sa pinapanood siya ng mga clients niya who are online. Di ba? At the same time, that is rape because it is against the will of the victim. So, two crimes were committed. So, qualified rape. Ika? Ang qualified rape exists if the victim is below the age of 18 and the offender is relative of, and the accused is relative of the victim. Two circumstances must be proven. One, that the victim is a minor, and number two, that the offender is a relative, whether ascendant, parent, diba? A relative within the third degree of consanguinity, or the offender is the common law spouse of the victim's mother, or the victim or the offender is the stepfather of the victim. These two circumstances must be alleged in the information. Pag inallege mo kunyari stepfather and stepdaughter ang relasyon, there must be an explanation or allegation in information. Paano sila naging stepfather or stepdaughter? Paano? So ang stepfather relationship is created when there is marriage. Oh, marriage. pagkasal yung offender doon sa victim's biological mother. O, step parent yan. Pero kung walang kasal, ang nakikreate is common law relationship o common law spouse. Kung ang allegations sa information is stepfather, pero na-prove siya na hindi naman pala kasal after trial, walang qualified rape. Ang crime is only simple rape. Kasi iba yung senaryo ng stepfather sa common law spouse. Sa common law spouse, there's no marriage to speak of. Adopted uncle is not included. Kunyari, uncle, A adopted the victim, si B. Okay? Si A may kapatid, si X. Okay? Although ang uncle is included doon sa offender. Pero pag adoptive uncle lang siya, meaning si A inadopt si B. So, si X saka si B, adoption ang kanilang relasyon. Hindi po included ang adopted uncle. Why? Because the legal fiction created by adoption is only true between the adopter and the adopted child. A legal guardian is one who exercises parental authority over a child. Okay? Actual guardian is not a legal guardian. So, if he is not qualified to be a legal guardian, so, nirape niya yung victim, that is not qualified rape. That is only simple rape. Ito hindi pa tinanong to nung nakaraang bar exam. People versus Trip ABC. Tandaan nyo to, napaka-importante nito dahil en banc to. If, for example, the victim is below 12, pero ngayon, 16 na, dahil may, so I'm using the old law because this was decided under the old law. Kunyari, 11 years old yung victim. And the offender is the father of the victim. So, pwede siyang makonsider na statutory rape since the victim's age is below 12. At the same time, pwede rin siya makonsider as qualified rape kasi minor siya at ang offender is a father. So, anong tawag? What is the proper crime? Ang proper crime, pwede bang qualified statutory rape? So, sabi dito, there's no crime of qualified statutory rape. Ang crime is qualified rape of a minor. So, if these two elements concur, kunyari, below 12, and the offender is the father, for example, hindi siya magiging qualified statutory rape, but is qualified rape of a minor. People versus Triple Z. Ano ba to? June 26, 2024. Napakabago rin. This law, Article 266-A, B of the Revised Penal Code, which provides for the qualified circumstances, applies only to rape by sexual intercourse. Bakit kinalify? There are two kinds of rape now. Rape by sexual intercourse and rape by sexual assault. So yung qualification under 266B, yung qualified circumstances, will not apply if it is rape by sexual assault. This is apparent, according to the Supreme Court, from the phrase rape under paragraph 1. Pag sinabi mong rape under paragraph 1, it only pertains to rape by sexual intercourse. So yung qualified, ang dami nun. Okay? Ang isa nun is if rape below 7 years old. Okay? If the victim age is below 7, nagiging qualifying yon, magiging ang penalty reclusion perpetua to death. Okay? So, mag-a-apply lang daw yung mga circumstances na yon pag rape by sexual intercourse. So, do not apply this if the rape is by sexual assault. Sa grave threats, eto, lalabas to, si Garma. Ponensya to ni Justice Javier. Sa grave threats, once na if you utter grave threat, or if you utter that, kunyari, if the offender said, papatayin kita, or that is an utterance of killing. So there is grave threats. So, under the revised penal code, the mere act of uttering threats is a crime of grave threats. In Garma versus People, the Supreme Court explained that this crime would exist only if there is a mens rea. There is mens rea, malicious intent on the part of the offender. So pag walang mens rea pala, walang crime, even if there is an utterance of a threat. Anong nangyari sa Garma? Si Garma, saka yung kanyang twin, hinahabol yung nagnakaw ng mga isda doon sa fish pond niya. Nung hinahabol niya, may nadaanan siyang group of farmers. Huminto. Nakita mo ba yung nagnakaw doon sa fish pond? So yung farmer sabi niya, hindi. Si Garma, yung isang twin, nagsabi, nasaan ba si Kapitan? O, yung kanilang kapitan, tinatanong, ay wala po dito, nasa bahay nila. Pakisabi kay Kapitan, pag nakita ko siya, papatayin ko siya. Ayan. So nagsumbong yung mga farmer sa Kapitan. Sabi niya, sabi ni Garma, pag nakita ka rin niya, papatayin ka. So nag-file yung Kapitan ng grave threats against Garma. Na-convict siya ng grave threats, but Supreme Court acquitted Garma through Justice Amy Javier. Ano bang sinabi ni Justice Javier? Sabi niya, there's no mens rea if there are no other instances of utterance of threats. Isang beses lang ginawa ni Garma yung pakisabi kay Kapitan, papatayin ko siya. Ibig sabihin, if the accused did not intend, or if the accused did not intend that the recipient of his word, the victim would feel intimidated. So, pag hindi naman if the accused did not intend the victim to be intimidated, doon sa sinabi niya, walang grave threats. Wala rin mens rea. So, pag magkakaroon lang ng grave threats, pag may mens rea, walang mens rea if there's only a single utterance of threats. Just like what happened in this case of Garma. Isang beses lang naman sinabi ni Garma na napapatayin. Ibig sabihin, hindi naman sineryoso ni Garma yung kanyang threat na papatayin niya. Okay. Ito mga hindi masyado na. Ito, People versus De Les Reyes. August 11, 2023, serious illegal detention. Dito, napakahalaga nito. Marami pong, there are quite number of law students or bar examinees na pag walang detention, walang crime ng serious illegal detention. So, anong klaseng detention ba? What is the nature of detention required in serious illegal detention? Is it necessary that the victim be kept inside the room? Is it necessary that the victim be handcuffed o igapos? Is it necessary na kailangan niyang ikulong para mayroong detention? Ang sabi ngayon ng Supreme Court, that is no longer necessary. Kunyari, ang kailangan lang is intent to deprive liberty. The offender must have that intent to deprive the victim of his or her liberty. If that exists, there is detention. So kunyari, tinakot mo, uy, huwag kang lalabas dito sa bahay. Pag lumabas ka, papatayin kita, babarilin kita. That is detention. Because there is intent to deprive him of his liberty. Yung, subukan mong lumabas dyan sa gate. Papatayin kita, babarilin kita. If it created a fear in the mind of the victim, then there is deprivation of liberty. Sa People versus De Les Reyes, yung victim, kasama doon sa initiation sa tao gamma fee. Si De Los Reyes, member na siya ng Tau Gamma Phi. Habang nagiinuman siya, kasi sinama niya yung kanyang yung victim na 15-year-old. Habang nagiinom, inutusan niyang bumili ng pagkain. Pagbalik niya, napagtripan niya si victim. Sabi niya, umatras ka nga. Atras. Okay? Hindi atras. Move forward. 10 steps forward. So, sumunod naman yung victim. On his 4th step, tinulak siya ni De Los Reyes sa balon. Malalim, 20 feet deep. He was not able to extricate himself. 2 araw pa siya naging nakulong doon sa balon na yun. Hindi siya nakalabas. Siguro may tumulong sa kanya. Meron bang serious illegal detention? If tinulak lang? Sabi ng Korte Suprema, yes. The essence of serious illegal detention is the actual deprivation of the victim's liberty. But it does not only consist of placing a person in an enclosure. Ito yung maganda. It also consists in detaining or depriving the person in any manner of his or her liberty. So there was serious illegal detention. Now in People versus Ulidan, August 14, 2024, 2 of the 9 accused were active members of the PNP. They kidnapped 3 children and demanded ransom. Now, si Ulidan, ang role lang niya is caretaker siya ng victim. While the victim was being kept, siya lang yung nagpapakain siguro, siya lang tumitingin doon sa victim. Now, nademanda siya ng kidnapping. Ang sabi niya, I was not involved in the actual abduction of the victim. Ang role ko lang naman dito is bantayan. Sabi ng Korte Suprema, your defense is not meritorious since your involvement, your participation is in furtherance of kidnapping for ransom. Kahit hindi ka involved sa actual abduction, you're also guilty because the act of your co-accused is also your act. So, since there is conspiracy. In People versus Katakutan, tinanong na to last bar exam. In the crime of robbery with homicide, ano yung dapat nang tandaan? The first principle is, the original intent of the offender is to commit robbery. And killing is committed by reason or on occasion of robbery. So, the original intent is to commit robbery. If that is not the original intent, for example, the taking of property is a mere afterthought, that is not robbery with homicide. Pero hindi natin itatanong, kasi tinanong na siya last year. Ito yung si Katakutan, callboy siya. Then yung victim na isang bading, isang bakla, pinapunta niya si Katakutan sa kanyang condo unit. And after they agreed na the victim offered to pay him 1,000 pesos for his services. After they had sex, the victim only paid him 500 pesos, kalahati. Tapos nakatulog na yung victim, sinaksak niya. After killing, he took valuables from the victim. He was charged and convicted of robbery with homicide, but the Supreme Court, through Justice Mario Lopez, modified the conviction to theft and homicide only, because it was not established that the original intent of the victim was to commit robbery. The taking of personal property was only afterthought. Now, People versus XXX, in robbery with rape, the offender must be involved, must have participated in unlawful taking. In People versus XXX, the mother of the victim was awakened when she heard noises. When he peeped through the window, he saw a man taking away their valuables. Nasa labas na ng bahay. And he heard some noise coming from the room of her daughter. When she proceeded to the room of her daughter, she found XXX raping the victim. Now, on the belief that the XXX was also involved in taking of valuables, on the belief that XXX was a co-conspirator of that man earlier seen taking valuables, chinarge siya ng robbery with rape. But sabi ng Korte Suprema, that is not robbery with rape, that is only rape because XXX was not involved in taking of valuables. Pero People versus Barrera, what kind of rape is contemplated in robbery with rape? There are two kinds of rape. Rape by sexual assault and rape by sexual intercourse. Yun bang, if for example, after committing the robbery, the offender inserted his finger inside the vagina of the victim, will it constitute robbery with rape? The answer is no. In Barrera, the Supreme Court said the rape there does not include sexual assault. There are two cases. The case of Yamera and Datuin ata. People versus Datuin, 2016. People versus Yamera, 2018. Sabi niya, ang rape daw doon is either rape by sexual assault or sexual intercourse. But sabi ng Korte Suprema in Barrera, it is only rape by sexual intercourse because ang rape by sexual assault was only introduced in 1997. Okay? Ang robbery with rape na introduced 1992 by virtue of Republic Act 7659. So when Republic Act 7659 was enacted, there was no rape by sexual assault yet. So ang na-contemplate ng Congress ay rape by sexual intercourse. In People versus Cordial, na-reiterate si Barrera, yan, for robbers, and they committed robbery. After committing robbery, they went upstairs and entered the room of the victim's daughter. One tied her hands, and the other pulled down her shorts and panties, touched her vagina, and inserted his finger. While the other who tied the hands marched her breast. Ano yung crime ng apat? Ayan. Robbery, doon sa in taking of valuables. Sexual assault, when one of the robbers inserted his finger, and acts of lasciviousness, the one committed by the offender who masked the breast of the accused. Okay. There's no special complex crime of robbery with sexual assault. Ayan. Nireiterate na si Barrera na ang crime is robbery with robbery with rape pertains only to robbery or pertains only to rape by sexual intercourse. Okay. Di Maapi versus People. Robbery in uninhabited place. There are two kinds of robberies under 299 and 302. Sa 299, inhabited place, 302, uninhabited place. Ang allegation sa information that the robbery was committed in the house and store. Ang charge dito is uninhabited place. Pwede ba siyang mag-charge ng inhabited dahil ang store, ang house, is also used, or meaning, ang store was occupied by persons. Okay. There is a variance in the allegations or in the information. Ang title, uninhabited, pero ang house, ang place is house, which is also used as a store, and it was occupied. Okay. A robbery committed in a store, which also serves as a dwelling place, cannot be considered as a robbery in an inhabited house if the information fails to allege such store was also used and occupied as a dwelling. Magkaiba po kasi yung inhabited under Article 299 sa uninhabited sa 302. So, there is a violation of the right of the accused to be informed of the nature and cause of accusation. So, obvious naman, pag inhabited, hindi siya uninhabited and vice versa. So, since ang allegation is inhabited siya, inhabited kasi yung store ginagamit din na bahay. So, hindi siya pwedeng ma-charge ng uninhabited o ma-convict ng inhabited. And vice versa. Kasi nga, magkaiba yung title, magkaiba yung allegation sa body ng information. Ito bago to, tumog versus people. One in possession of a stolen item is presumed the robber or thief. So, hindi na kinakailangan na prove how the unlawful taking was committed. If you are in possession of a recently stolen item, you are presumed to be the robber or thief. People versus Tiham, di pa ito tinanong, that before kang makonvict ng theft, there must be unlawful taking. Meaning, it must be proven that the offender committed unlawful taking. Ano bang nangyari dito sa Tiham? Yung victim, nag-aantay siya ng bus sa MOA. Rush hour yun, ano? When the bus arrived, Mugot, the victim, along with other commuters, rushed inside the bus. Mugot realized when he was already on board the bus that his cell phone was missing. So when he looked through the window, he saw that Tiham handing over the phone to Baksid. So, nakita niya si Tiham, pinapasa yung phone niya kay Baksid. Thinking that it was Tiham who is nuts or who pickpocket, okay, the item, the cell phone from him, dinimanda niya si Tiham and Baksid. But the Supreme Court said that Tiham should be acquitted. It was not shown, both accused must be acquitted. It was not shown that Tiham was involved in the unlawful taking. What was proven by Baksid, Mugot, that he merely saw Tiham handing over the phone to Baksid. The act of pinning did not establish unlawful taking. Medyo kakaiba to. So itong qualified theft, mga minor cases to, si Tarado and people. Ito si Pineda, medyo bago-bago. Qualified theft. There are qualifying circumstances. Marami yan. When the act of taking was committed during calamity. Di ba? Kung yan, nagbabagyo, nasiraan ng kotse during vehicular accident, dinagnakawan mo, during fire, di ba, natural calamity, or taking of coconuts, qualified theft yun. Ang effect is 2 degrees higher ang penalty. So mataas, nako-qualify yung penalty. Ang pinaka-common dito, yung grave abuse of confidence. Diba? Grave abuse of confidence. So yan. So pag grave abuse of confidence, mayroong qualified theft. Kunyari, empleyado mo, nagnakaw sa'yo. So there is a grave abuse of confidence. Tinanong last time, Batislaon versus people. Yung cashier sa SM Hypermart. Sabi ng Justice Lopez, there was no qualified theft because the act of, Batislaon was not entrusted with the property of SM daw. Kasi mayroong mga camera, there was a CCTV on top of Batislaon, there was a bagger, there was a roving supervisor, there was a guard, that it was impossible for Batislaon to commit robbery or theft. Now, in Pineda, bago-bago to, Pineda was employed as sales coordinator of her employer. She was entrusted with money to be used in purchasing bid documents and from the procuring government agencies. Aba, kahit binigyan siya ng pera ng kanyang employer, hindi naman nakapag-participate ang kanilang company sa bidding. Dahil sabi ng employer, minisappropriate niya yung pera binigay. So he was charged with qualified theft. Here, the Supreme Court modified the conviction from qualified theft to simple theft because the allegation in the information is only abuse of confidence. Ang kailangan daw, grave abuse of confidence. So, nagkamali yung fiscal. If the allegation in the information is only abuse of confidence, that is not qualifying but merely generic aggravating circumstance. What is required in qualified theft is grave abuse of confidence. Grave abuse of confidence by a thieving employee should be contextualized not only by the relationship but also the purpose by which the employee was given the employer's trust. So, hindi lang relasyon daw, yung purpose. Bakit ka, why were you hired by the corporation, by the company? Bakit ka kinuwang empleyado? Anong purpose? Yan ang mga katanungan. When the gravity of exploitation is not proven, the crime is only simple theft, and the abuse of confidence is merely generic aggravating circumstance. Ito, hindi ko na ito kukunin. O ito si Dueñas versus People. Dueñas, ahente siya, sales agent, ng isang used car shop. Nakabenta si Dueñas ng isang kotse at he did not remit the proceeds of the sales and he misappropriated it. He was charged with carnapping because the subject of the sale, yung pinagbenta niya, is a car or a motor vehicle. The Supreme Court said that is not a proper crime, carnapping. The proper crime was theft or qualified theft because what was misappropriated by him is not the car but merely the proceeds of the sale. Itong paluwagan association, a treasurer cannot be accused of estafa. Okay? Kumbaga, if the treasurer cannot account the funds of the association, because ang sabi niya, saan yung mga pundo? Nasa utangan. Nasa utangan. Yung mga ininvest yung pera sa paluwagan, nasa utangan. Her failure to return the money upon demand was due to the fact that the borrowers failed to pay their loans o hindi nakabayad yung mga nag-loan. So, hindi ako pwedeng ma-charge ng estafa. Using fictitious name and speaking English with feigned foreign accent is estafa. In People versus Ortico misrepresented that he was a Greek. Her name was Lateia Estefanos Estelos. So, nagpakilala siya isang Griego. But her true name was Elnora Mandelman. And that is estafa. Using fictitious sounding name. Fernando versus People, yung isang travel agency. Fernando misrepresented that he was an accredited travel agent by the IATA, International Association of Travel Agencies. Yung victim availed of the package offered by Fernando, yung Disneyland sa Hong Kong. Despite payment of that package, hindi nakaalis yung victim, hindi nakapunta ng Hong Kong, naloko siya. Chinarge sila si Fernando ng estafa by deceit. Ang sabi ng Korte Suprema, there's no estafa there. The fact that even if Fernando misrepresented as an accredited travel agent, that is not deceit. Why? Because this practice is acceptable among travel agencies. Well, I do not agree with this. Paano naman malalaman ni victim na siya, accredited or not? Yun nga, siyempre, pag sinabi mo accredited ka, yun ang nag-assure siya yun. That is an assurance that you are really an accredited travel agent. But the Supreme Court said that is not deceit because that is acceptable among travel agencies. Ito magandang kaso, Leonilo versus People. Ang sabi ni Leonilo dito sa victim, yung apartment unit na binebenta niya, pwede siyang mabili mo under sangla tira arrangement. Oh. Para bang, kunin mo na to, yung parang, yung pangbabayad mo, pwede ka nang, yun ang kabilhan mo. In exchange for a loan. Kumbaga, maglo-loan ako, gagamitin mo yung bahay, yun ang pinababayad mo sa loan, yung sangla, tira. Sasangla mo, pwede ka nang tumira. The accused assured the victim that the unit was unencumbered. It was not mortgage. And relying on that assurance, the victim granted the loan application. Hindi na bayaran. Okay? The victim, the accused, started occupying the premises. And the interest of the loan would serve as the rentals for the use of the unit. Upon verification with the register of deeds, this apartment unit was mortgaged to different banks, contrary to the representation of Leonil. Is that tapa? Sabi ng Korte Suprema, no daw. Because the victim has been shown with a copy, Xerox copy of the TCT or an OCT title of the land, and it was annotated therein that there was a mortgage. Hindi ata napansin ng victim that there was an annotation of mortgage on the title. Hindi raw yun estafa. So deceit presupposes valid transaction and estafa by post-dating check. Under Article 315(2)(d). Okay? If you issued a post-dated check in payment of an obligation, that obligation, that there must be a valid transaction. If there's no valid transaction, there is no deceit. Okay? In order to constitute estafa or deceit for the crime of estafa, that transaction must be valid, or there must be an existing valid transaction. If there is none, there is no element of deceit. This is a new case. People versus Amelia Pabros. She was a presiding judge. Judge siya, no? Honorable presiding judge, Amelia Pabros et al. The penalty for estafa by post-dating check under Republic Act 10951. Yun ang amendment, yung amendments sa revised penal code with respect to the penalties. So, there are two groups of penalties for estafa under Republic Act 10951. The first group is the penalty imposed by the RPC, while the second group is the penalty for estafa committed by specific fraudulent means, including the issuance of worthless check. So if it is estafa by post-dating check, you apply the second group. Do not apply the first group. That is not proper. It is not proper. So there's a specific penalty for estafa by post-dating check, and that is the second group under Section 25 for the amendment, Republic Act 10951. Adultery. Ayan. Sturis revuelta. In Sturis versus Revuelta, there was an issue regarding whether sexual intercourse was proven by the prosecution. Revuelta, the wife, was with her paramour and 3-year-old son. Na-trace si Revuelta nung kanyang husband at may kasamang pulis na nasa loob ng motel. And of course, the wife denied that they had sexual intercourse. Dininay niya, wala, di naman kami nung madatnan mo kami, di naman kami nagtatalik. So there was no adultery. Is that proper? Is that a proper defense? The Supreme Court said no. Even if you're not caught in flagrante having sexual intercourse, the fact that you were inside the motel together with your paramour, those circumstances are enough to establish sexual intercourse. These circumstances are enough to make a reasonable inference that the two accused could not have gone inside a motel room for wholesome activities. Valencia versus People, another case of adultery. Valencia was the paramour of the wife. Okay? Yung wife na co-accused, may asawang husband na seaman. Si Valencia isang ahente. Magaling sa mambola. Yung wife may isang restaurant sa probinsya. Nung malaman ni Valencia na yung wife nasa abroad yung asawa, pinag-isipan niya, niligawan niya, and naging sila. Sinasabihan yung husband ng kanyang mga magulang at kapatid, "Kuya, umuwi ka na rito, yung asawa mo, iniwan ka na." So umuwi si husband, na-confirm niya na wala na nga yung kanyang wife, andun na kay Valencia. Sinundo pa ni husband yung kanyang asawa. Umuwi yung wife niya na tinanggap pa ni husband. They lived together for 6 days. At after 6 days, the wife abandoned the husband. That's the time for the husband to file a case against them for adultery. Na-convict si Valencia because the wife was at large. Valencia questioned his conviction. Sabi niya, wala naman sexual intercourse na naganap. At kung meron man, meron pardon. Pinatawad ni husband si wife at yung pagpapatawad, the pardon, extended to me. Ano bang sabi ng Korte Suprema? Doon sa first issue, whether there was sexual intercourse, sabi nung anak niya, si Munabi, nag-testify that Robirosa, the wife, and Valencia were always hugging and kissing each other. And they would even sleep together while covered by a blanket. At one time, nakita ni Robirosa, yung kanyang nanay, nasa on top of Valencia. There was sexual intercourse. And regarding the pardon, sabi niya, Valencia, sabi ng Supreme Court, para magkaroon ng pardon, for pardon to be valid, there must be a resumption of sexual intimacy between the accused and the victim. So, ang na-prove mo lang, nagsama ulit, but di naman sila nag-sexual intercourse. You did not prove that there was sexual intercourse between the husband and the wife. Concubinage, the latest is Singgit versus People. There are 3 kinds of concubinage under Article 334. 1, by keeping a mistress in a conjugal abode. 2, by having sexual intercourse under scandalous circumstances. And 3, by cohabitation in any other place. Ang nangyari kay Singgit, ang nai-allege sa information is keeping a mistress in a private dwelling. So para bang combination siya ng first and third kinds of concubinage. So, ang first kind, keeping a mistress in a conjugal abode. So ang nasabi, hindi conjugal abode but private dwelling. Hindi pa pwedeng ma-convict si Singgit because magkaiba yung allegation. The Supreme Court said, by the way, nasite ang book ko dito ni Justice Garland. Sabi, pwede siya na ma-convict under the third mode. Even if it was not alleged na conjugal abode, even if the act would not fall under the first kind of concubinage, the act would fall under the number 3 type of concubinage. Cohabitation in any other place. So pwede ma-convict under the third form of concubinage. Lascivious conduct, can be performed in public places. This is the case of Villarante versus People na inabandon na yung lumang doktrina na pag sabi niya pag in a public place there can be no lewd design. But in Villarante, nasa canteen sila, school canteen. There can be lewd design. Lewd acts can be committed in public place. Forcible abduction. After this, we will have a break. Now, this is a ponencia of Justice Amy Javier, Romero versus People. Ang problem dito, if in addition to forcible abduction, the offender raped the victim, what would be the proper crime? Is it forcible abduction? Is it rape? Or is it forcible abduction with rape? Kunyari, A abducted B with lewd design. And in the course of detention or captivity, A raped the victim thrice. Ano bang crime? Pwede bang forcible abduction or forcible abduction with rape or rape lang? Now, in case of Romero versus People, si Romero nakasakay sa tricycle. Yung victim sumakay din sa tricycle. While na nasa loob sa ng tricycle, si Romero covered the victim's mouth with a handkerchief with a strong, ano ba yun? With a foul-smelling handkerchief. The victim lost her consciousness. When she regained her consciousness, nasa loob na siya ng isang cottage sa isang beach. Cottage, no? At wala nang katao-tao doon. Wala na si Romero saka yung driver ng tricycle. At ang nakita lang niya is mga bote ng emperador. At yung kanyang underwear nasa lapag at masakit yung kanyang ari. Ano yung crime ni Romero? The ponente, Justice Javier, sabi niya, ma-determine mo kung forcible abduction yan or forcible abduction with rape if, kunyari, after abducting and raping, the victim was free or the offender abandoned her. Pag wala ng detention after the rape, ang proper crime is rape only. The abduction is absorbed by rape because that is the intent or objective of the offender is to rape. Pero pag after raping, the victim was still detained by the offender. That would constitute forcible abduction with rape. In this particular case, since Romero left or abandoned the victim after raping her, the proper crime is only rape. So, tatandaan nyo to ha. So, baka lumabas to dahil isa to sa mga decisions na ginawa ni Justice Amy Javier. So, after forcible abduction, we will go to bigamy under Article 249 of the Revised Penal Code. This has not yet been asked Pulido case. Okay? This is an en banc ruling of the Supreme Court, July 27, 2021. Sana hindi ko nasasama to, but to those who have not yet read this case of Pulido, napakasimple lang, ano? So, in case of Pulido versus People, that it is not necessary to have a judicial declaration of a void marriage. So, yung requirement under Article 40 of the Family Code that there must be a judicial declaration first of a void marriage is not applicable in bigamy. So if the marriage is void ab initio and that marriage is under Article 335, 36, 37, 38 ata, and 52 of the revised of the Family Code, you don't have to file a petition for nullity of marriage, and if you contract subsequent marriage without judicial declaration of the first marriage, that is not bigamy. There's no bigamy. Okay? So if the first marriage is void ab initio, assuming it is against public policy, marriage between first cousin, you don't have to get a declaration of the nullity of that marriage. If you contract subsequent marriage, there can be no bigamy because the effects of the first marriage retroact to the date of the first marriage. So it is as if the accused did not contract first marriage. Bermudez versus people. So in this case of Bermudez, the Supreme Court reiterated the ruling in Pulido. Okay? Bermudez contracted first marriage with his childhood sweetheart. It was a marriage in jest. That is the description given by the Supreme Court, since after the first marriage, Bermudez did not live with his supposed first wife. So they did not live together. So after a while, Bermudez met another woman and he proposed marriage to that woman. And they were married. But their marriage was short-lived. So they separated thinking that the marriage was void. Bermudez went to his first wife. Okay? Yung kanyang childhood sweetheart. And they were married. So Bermudez, all in all, contracted 3 separate marriages. First, yung kanyang childhood sweetheart na marriage in jest kasi hindi naman sila nagsama. Second, yung kanyang pinakasalang babae na meet niya. And third, yung kanyang childhood sweetheart. Now, question, bigamous ba? Is Bermudez guilty of bigamy? Now, let's analyze. Yung first marriage niya, yung tinatawag natin marriage in jest, it was a void marriage according to the Supreme Court. Because the parties did not intend to be bound by that marriage. Because they live separately. So, it was a void marriage. So, following Pulido, the effects of a void marriage retroact to the date of marriage, first marriage. It is as if there was no marriage at all. So when Bermudez contracted second marriage, it was a perfectly valid marriage. Kasi hindi mo naman kailangan ng judicial declaration. When Bermudez married for the second time yung kanyang childhood sweetheart, it was a bigamous marriage because the second marriage was valid. So when he contracted marriage yung kanyang childhood sweetheart, it was bigamous because the marriage, yung sa kanyang second marriage is a valid marriage. Henyo versus people. So 2024, hindi pa siya tinanong dito. Hindi pa ito tinanong sa bar exam. So si Henyo, kasal. Okay? Taga Las Piñas ata siya. Now, when Henyo worked in Quezon City, he met a woman na pinakasalan niya. So, si Henyo, loko-loko. Kasi yung kanyang pagpapakasal, yung kanyang reception pala, pinost sa kanyang Facebook. So, nakita ng kanyang first wife. So, the first wife went to the restaurant where the reception was held. At nakakuha siya ng mga certification o saka picture na nagkaroon ng reception doon sa restaurant na yun. At the same time, the first wife also obtained a certified true copy of the marriage contract entered into by Henyo and his second wife. Based on those evidence, nag-file siya ng bigamy case against Henyo. Anong nangyari dito? Liable ba si Henyo? Since the first marriage was valid. Henyo was acquitted because the second marriage was not proven. In order to constitute the crime of bigamy, both the first and the second marriages must have the essential and formal requisites of a valid marriage. So the second marriage was not proven to have all the essential and formal requisites of marriage, because it was not proven that the marriage, the second marriage, was valid. Because what happened here is that the accused Henyo admitted the existence of a valid marriage contract. Supreme Court said it is not enough to establish the second marriage by just presenting the marriage contract. The prosecution must still prove that the second marriage had all the essential and formal requisites of marriage. In this case of Henyo, there was no valid marriage because there was no marriage ceremony that took place. There was no solemnizing officer who appeared to officiate the marriage. Therefore, there was no valid marriage. That's why Henyo was acquitted. But Henyo, although acquitted for the crime of bigamy, was liable for marriage contracted against the provision of the law under Article 350. This crime exists if the party is aware of a legal impediment to contract subsequent marriage. Here, Henyo was aware that he was previously married and he contracted second marriage, then he is liable under 350 of the revised penal code. Now, the case of Malaki versus People, the fact that the offender converted to Islam faith or to Muslim, it does not eligible him to remarry. Although under the Muslim code, a Muslim may contract up to 5 or 4 marriages. But you have to fulfill the requirements of the Sharia law. Mere conversion is not enough. If you are a Muslim who wishes to contract subsequent marriage, you have to get first the consent of your first wife. If the first wife consents or agrees, then there will be no problem. You can remarry. You can contract subsequent marriage. If the first wife objects or does not give her consent, you cannot marry or contract subsequent marriage unless you file a petition before the Sharia court. If the Sharia court grants your petition, it will appoint elders who will convince the first wife to give her consent. If the first wife still refuses to give her consent, then it will be the elders who will give the consent. Therefore, the go signal for the person who wishes to contract subsequent marriage. Yung libel, Castro versus Atty. Soriano, that Atty. Soriano sent a demand letter to Castro. The demand letter pertained to a notice to vacate. The lawyer wanted Castro to vacate the property. He mentioned in the letter that Castro was a mere mistress of his client. So, pinaratangan niya si Castro, isa ka lang kirida ng aking client. So, wala kang karapatan na mag-stay sa premises. Well, nagalit si Castro. Bakit mo pinaparatangan ng kirida? So, that is libelous. But the Supreme Court said no. That is a privileged communication on the part of the lawyer because a legal notice ascribing to the victim as the mistress is considered a privileged communication. So that is being a privileged communication that there will be no libel. So if you encounter this case, Peñalosa versus Ocampo, because this is recent also, 2023, do not be confused do not be confused if you read Peñalosa vis-a-vis the case of Dicine versus Secretary of Justice. Okay? Ang Peñalosa kasi, this was filed when the Cyber Law or the Cybercrime Prevention Act, Republic Act 10175, was not yet enacted. So, there can be no, the complainant here in Peñalosa filed a cyber libel case against the respondent based on the Facebook post of the respondent. A Facebook post is covered by Republic Act 10175, Cybercrime Prevention Act. When this complaint was filed, that law was not yet enacted. Pero ang ginamit niya is 355 or the libel under the revised penal code. Hindi pwedeng mapaloob, you cannot apply 355 or you cannot use Article 355 if it is cyber libel. Pag cyber libel, the law is Republic Act 10175, the Cybercrime Prevention Act. Hindi mo pwedeng gamitin yung revised penal code sa cyber libel because that is not contemplated sa revised penal code. So, nung mangyari kasi ito, wala pa yung Republic Act 10175. Libel and cyber libel are not the same. Kasi ang cyber libel, nag-exist lang siya sa Republic Act 10175. Pero, since meron na tayong law na cyber libel, magkaparehas yun, sabi sa Dicine. The only element lacking in libel is the use of computer or internet. If there is a use of computer or internet, libel pa rin yun. Yun nga alam, magiging cyber libel. Okay? So, magkaparehas yun. In that sense. So, itong kausing, cyber libel, ang prescriptive period is only 1 year, not 15 years. Arkisa versus people. Kasi, ang ating jurisprudence, pag qualifiedly privileged communication, okay? Ang absolutely privileged communication, there is no libel. Isang uri ng absolutely privileged communication is yung pleading or communication made by a lawyer or counsel in a judicial proceeding. Nakalagay yun sa ating batas, na revised penal code, if it is a pleading or a communication made in the course of judicial proceeding, there can be no libel. Kasi nga, privileged communication. But in Arkisa versus people, pag itinanong to sa bar, it is included daw yung quasi-judicial proceedings or proceedings before the commission and election. Mayroon kasing proceeding doon na pinapadisqualify yung isang kandidato sa isang party list nominees or party list nominees sa senior citizen party list. Pinapadisqualify yon kasi sabi niya that nominee is a fugitive from justice. At meron daw itong mga kaso, string of criminal cases. So, disqualified siya na maging nominee. So, kinasuhan siya ng libel. Ang sabi ni Arkisa, that is a privileged communication. And he was upheld by the Supreme Court. That statements made in quasi-judicial proceedings, just like COMELEC proceedings, is included as one of the absolutely privileged communication. So with this, I hope I have already done my part in discussing the latest jurisprudence of or decisions 2020, 2021, 2023, 2024 cases. I hope this lecture sponsored by PALS or Philippine Association of Law Schools in coordination with Central Bookstore, of which I am an author, and sana makatulong to sa para examination niyo. So, good luck sa inyong lahat, and mag-aral pa, may panahon pa para mag-aral. And pagdating ng bar exams, I hope makapasa kayo. So, thank you and good day sa inyong lahat.
Thank you very much, Prosecutor Nojara, for delivering such a comprehensive and insightful lecture on criminal law. I am confident that our law students and our baristas for this year's bar exams now have a clearer understanding of the key legal concepts in criminal law. A knowledge that will undoubtedly serve them well as they prepare for the 2025 bar examinations. Again, if you want to look at our other lectures, just visit the official Facebook page of Central Books to be updated on the dates and speakers. So I guess that's it for our lecture on criminal law today. Again, this is Hannah, your host, and I will see you on our other lectures.